to Jackson. Good morning. Morning. Good. Good morning. Got the whole family this morning. Good morning. You're Janisha Jackson. And Miss Jackson, were you able to get a lawyer hired?
But I did check. She said that it's very expensive.
Who'd you talk to?
Burbanks, Payments,
Say it again. I'm sorry, I can't hear you.
Burbanks,
Uh-huh.
and I talked to Taylor Walker and Lane Walker Jr. and Sales and Son Law Firm.
Okay. Are you working?
I do work at Riceland, but I don't have a client right now.
Okay.
I'm waiting on a client around my kids' school schedule.
Okay. So what I'm going to do, thank you for doing what I asked you to. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. Don't just leave it all blank or put zeros. You're going to swear under oath that it's all true, okay? So if you step in front of the clerk, she'll give you that paperwork. Clifford Norman. Morning, George. Good. How about you? It's Monday.
Good morning, Your Honor.
Good morning, sir. Are you Clifford Norman?
Yes, ma'am.
And Mr. Norman, this is your initial appearance in cause number 25 DCCR 1034. You're charged with, my computer's going slow. You're charged with something.
They said go back.
Yes. All right. The second degree felony offense of aggravated assault with a deadly weapon, and that's from July 15th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am, I can't afford one right now. I'm a disabled vet, so I've been doing community service work, volunteers, where I stay at now.
Do you receive disability?
Yes,
How much do you receive a month?
2244.
All right. So I will find that you qualify for a court-appointed lawyer. Step in front of the clerk. She might need a minute to let you know that information, and step in front of the clerk right here. She'll tell you what to do. Presley Viltz. Good morning, sir. You're Presley Viltz. And Mr. Viltz, were you able to get someone hired? I can't hear you. To who? Livingston Scott? Okay, let me see. Is he local?
Yeah. Well,
Langston? Scott, Mr. Adams?
yeah.
Okay. And so when are you going to be able to get him hired? I don't know why you're whispering, but I can't hear you. The end of the month? Okay. So I'm going to reset your case one more time to get Mr. Adams hired. If you get him hired, bring the reset notice that you get today to him. He'll tell you what to do. If you're unable to hire him and that's not going to work for some reason, then you need to talk to at least 3 others and bring me those names. Okay. All right. If you'll step right behind him here in front of the clerk, she'll give you that reset notice. And it's Mr. Adams. Is it just me? I can't hear anything. Adrian Howard. Adrian Howard. I can't, I'm telling you, I don't know what's wrong. I can't hear anything this morning.
He has a COVID. Straight to jail.
Oh, gotcha.
Yes. You thank you, sir.
Spawn will be forfeited for non-appearance and reset at 100,000. Yep. Trinity Hughes. Trinity Hughes. You'll call the name, please.
Trinity Hughes. No response, Your Honor?
Her bond will be forfeited for non-appearance and reset at 100,000. Kyra Rogers. Good morning. You're Kyra Rogers. And Ms. Rogers, this is your initial appearance in cause number 25 DCCR 0976. You're charged with the state jail felony offense of theft of service from June 5th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
When I had talked to the real one, people, they told me that I was going to be a court appointed.
Right. So when you were in custody, we automatically give you a court-appointed lawyer. But once you bond out, what I do is expect you at least to try to hire a lawyer. So I'm going to reset your case for about 30 days to give you some time to see if you can get a lawyer hired.
And I can get a court appointed.
Listen to what I'm saying. You have to try to hire a lawyer, okay? If you get a lawyer hired, then you need to bring the reset notice to that lawyer. They'll tell you what to do. If you are unable to hire a lawyer, I want you to talk to at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers that you've talked to so that I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? Okay, step in front of the clerk. Jaden Simon. Good. You're Jaden Simon?
Yes, ma'am.
And Mr. Simon, you are here on initial appearance in cause number 25 DCCR 0918. You're charged with the second-degree felony offense of robbery from June 12th of 2025. And since you have made bond, have you had an opportunity to try to hire a lawyer?
Not at the moment.
How old are you?
17,
Are you in school or are you working?
in school,
Where do you go to school?
Brown.
Okay. And so do you have a family that's going to help you hire a lawyer, or do you want me to consider appointing you a lawyer since you're still in school?
I'm family.
Okay, so y'all are going to try to hire someone?
Yes, ma'am.
So what I'll do, Mr. Simon, is reset your case for about 30 days to give you some time to hire somebody. If you get a lawyer hired before the next court date, bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Yes.
If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers y'all talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order. Do you understand? All right, step in front of the clerk. She'll give you a reset notice.
Sign right there.
Brendell Griffin.
Thank you.
You okay?
Yes, thank you.
Yeah, good.
Good morning, sir. Are you Brendell Griffin?
Yes, ma'am.
And Mr. Griffin, this is your initial appearance in cause number 24 DCCR 1666. You're charged with the state jail felony offense of publishing or threatened to publishing intimate visual material from June 24th of 2024. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, Mr. Griffin, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, bring the reset. I'm going to tell you, I got to say all the words. I know you sitting here heard it, and I'll never have somebody come back and say I didn't tell them the same thing. If you get someone hired, bring that reset notice to them. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. Make sure you bring those names back of who you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then you come back, I may raise your bond for not following that court order, and you would have to go back to jail. You understand? Where do you look? Google Jefferson County or Beaumont criminal attorneys. Okay. And also, if you walk right across the hall here, when you walk out of the courtroom, there's the Jefferson County Bar Association. They also have a referral service and they can give you a few attorneys' names as well. Shannon Stott.
Good morning, Judge.
Good morning, ma'am. You're Shannon Stott.
Yes, ma'am.
Ms. Stott, in cause number 23-41490, you're charged with the state jail felony offense of theft of service, and that's from July 15th of 2022. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
So what I'm going to do, Ms. Stott, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you talked to, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand? If you'll step in front of the clerk, she'll give you your reset notice. Yes, ma'am.
Thanks for saying the name.
Oh, yeah.
Everybody always says Stout or Scott.
Oh, yeah. Well, that was just a fluke because I'm usually wrong on most of them.
Can I ask you a question?
Yes,
Are
ma'am.
you on YouTube?
Yes, ma'am.
Okay. Follow you. Follow this stuff. Am I done?
Yes.
Okay.
Let's see.
Thank you. Thank you.
Yes, ma'am. Mr. Turk, you've got pretrial on a Ricardo Rodriguez. Mr. Coleman.
I
Morning.
do. Morning, how are you?
Ricardo Rodriguez.
Mr. Rodriguez is apparently incarcerated in Edwards County.
Hmm.
GLP there?
Yes.
One judge.
Morning.
I learned that recently. Oh, that's why he's not returning my phone calls.
There's that.
There's that.
No response, Your Honor.
So he's where?
Edwards County, and I think the city is Rock Springs, but it's 6.5 hours west of here.
Okay.
It's close, like Junction, that area, close to
Okay.
Big Bend area.
Mr. Coleman.
The state's ready for trial, Judge. We had a conversation late last week and I was hopeful that maybe could resolve.
Yeah, and I just always haven't been able to talk to him.
Sure. So, do you have any information now that you know where he is, the status of that or any?
He's on a revocation. I think he may be set next week. I've called a couple of times to the jail. They don't have a docket only, and so I'm hoping that it's quicker than not, but
Okay.
I can't tell the court over there what
This
to do.
one's old. Time to get this one taken care of, but obviously we can't do that if he's not here. If you would maybe contact the DA and maybe his defense attorney this afternoon, if y'all have a minute to do that. And just kind of let me know the status of if they think he's going to get out before next Monday.
Okay,
If he does, then I would like to go ahead and number the case, especially if there's a possibility of getting him back over here and y'all working something out. But just kind of let me know if y'all can this afternoon or tomorrow, any other status that you can find out.
okay.
Okay?
Just one quick logistics question, Judge, because this is going to require interpreters. And I kind of talked with everybody. Ms. Burge has been working with me to talk with witnesses and Mr. Rodriguez. I was under the impression she's going to sit with me at the table to talk with Mr. Rodriguez and
We've issued a subpoena for her for the state
to do what?
to interpret on our behalf.
So that was kind of one of my questions too, is I think there will be several Spanish speaking witnesses, but a lot of them, like the ones that are unemployed by the state, obviously the officers will speak English, but I need someone.
So I think an issue that we may have for witnesses is that we need we're gonna need one with the correct certifications. Ms. Burge has one of hers and is able to do that job. I'm not sure about her, I think it's required that we have, but it's not gonna be just, it sounds like we're gonna need one for several witnesses. So I think we would need master word for, I don't know, for one of the
Yes,
other.
right, that's what I'm.
And she does great. I'm fine with her doing either, but obviously we need to know that because we've got to get with master word to get either one for you or one for y'all. Either way,
My preference is to have Ms. Burge sit with it because she's up on speed with everything that I've been working on. So that would helpful. That way she can put things in context. And then for the trial, if we need one, the
We can get
new
master
person, so to
word.
speak.
okay. Let's just see where we are. Y'all,
Present a problem, Judge, if she's getting privy to conversations between he and his attorney.
I think
The defense,
my concern isn't that she would intentionally, because I don't think she would,
I don't think she would either.
but it's
no, but I think it would be best if she was there and we got,
it's just avoid any sort of appearances of harm.
well, and that would mean you guys would need to get someone else for witnesses. We'll take care of that logistically, but it sounds like we may not need to worry about it this time. So let's just see where we are, make some calls, and y'all let me know. Okay, all
Because I think we might be able to move something and get something done. Let me-
right. Thank you. Oh, I'm going to do this also, you guys, since he's in custody over there. I am going to find that he's at large without proper bond on these cases. That way, if something happens, he won't just get out. We can get him back here in custody, and that might help us logistically know what's going on. And so in each of his cases, I'm going to raise those bonds. What are they at now? Yeah.
This one's 50, the first one's 50.
Bless you. I bet they're both the same. They're both the same offense. Bless you. All right, I'm going to raise them both to 100,000 in each case. We've got a small docket team.
Intentional, because of that turn.
I forgot about that. How could I have forgotten about that?
Well.
Except from yesterday to today.
Yeah.
Mr. Reynolds, are you ready on Deshandra Joseph? Good morning.
Good morning.
Good morning, ma'am. You're Deshandra Joseph? And this is 24 DCCR 0708. Ms. Joseph is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Judge, she was previously offered, I think, for deferred, and she rejected that. I visited with her about the case, and I've received the discovery. Mr. Hoffmeyer is not here today. I believe it's his case. She's still rejecting that.
Okay,
And
ready to go on the trial docket?
We'll go to trial or have another announcement and let you talk to Mr. Hoffmeyer.
Well, y'all have had an opportunity to do that. I can't imagine it would get much better than a 4-year deferred probation offer. And so it's your intention, you want to go to trial and reject that? All right, we'll set it for trial. Mr. Reynolds will begin preparation for trial. If there's any change, y'all need to let me know well before the trial docket. Otherwise, once we get up to the trial docket, I'm not going to accept any other plea agreements, okay?
Yes, ma'am.
All right, stay in touch with Mr. Reynolds and he'll let you know when you need to be back and visit with him to get prepared.
Okay.
Thank you. That's it for lawyers.
Ms. Jackson?
Who?
Charlie.
Okay. Good. Mr. Burbank, Mr. Cole, Mr. Crenshaw, Mr. Ertz, Mr. Galmore, Mr. Himmler. Let me pull, we have a judicial review.
Thank you. Just gonna tell you, this is my favorite. See, they all have it, Mom. Come on, I know all people see challenges. That was to remind myself to not pout and just stuff was wonderful. Victoria, she's been dismissed.
Robert Joseph. Robert Joseph.
Robert Joseph.
Hey, Kristen, this is a judicial review. Do you know if,
She said she's on.
okay, well, it may not.
I'm sorry, I'm not familiar with that officer, so I wouldn't recognize him.
Stacy, no, I don't know if I am either.
No response, sir.
So if you will let the officer know that Mr. Joseph did not show up for this judicial review, and so it seems like the next step would just be an MTRP instead of a review. All right, thank you. He's not on one because it's just a judicial review. Well, you want to go round up some defense attorneys? They can't all be in front of a judge at the same time.
Mr. Livingston Scott. the front end. Talking to attorneys, said Livingston Scott. Which is licensed.
Adams.
That's quite-
I figured it out. Well, all right, court will be in a short break until we get some attorneys.
All rise.
Oh, yeah, they all piled up over there. They don't want to go crowd. I think he scanned the room. Our feedback or something.
He's not having trial this week. No, he's got okay. Girls trip. Girls trip.
He makes full of handcuffs. Just shove it out here. Sir, go outside. No, he's using the phone, so.
Which one's not there?
Hey, Langston, we're gonna put you last just because you, so. You're still anxious to go. Cody Garrett,
He's back. I got the one with Daniel.
huh?
I had the one with Daniel.
What are we gonna do with Cody Garrett? It's an announcement. We got 5 cases here, buddy, huh? We're gonna move some of these?
That's the.
It's Mr. Ham's cases. I'm standing in for him today, but there's 5 serious charges, Your Honor. I don't have any notes in there right now, but I'll look
It says
through it and see what we got.
announcement, so it,
But I did,
so it's so soon.
yeah,
That was from, 9/22. Then we got. It's familiar. Come on up. Okay, so. It's like on April 30th, Mr. Garrett here was the guest of honor at the grand jury. Because they indicted him on five separate charges. And those are first degree felony, a burglary of habitation with intent to commit a sexual offense, second degree felony of burglary of habitation. So that's life on the first one, up to 10 years on the second one, a third degree felony kidnapping. It's 20 years on that, and third degree felony of assault, family violence, choking, and the other third degree felony. So we're looking at
this person involved.
50 years plus life on all of these as the punishment potential in these type places. So obviously something we want to navigate here delicately. What today?
Your Honor, I'm sure Mr. Ham would like to speak with the victims on this to get a better idea of what offers going to be on it. I'm sure it's going to be I would take a pen time offer, but you better like to contact them and get a better idea of what exactly
It was 5 months have gone by. 5.5 months to be exact.
And Judge, to my understanding,
Yeah, we got to move quicker on these, especially these sorts of cases. These are treated by the law as priorities due to the nature of the case. But 5.5 months, come on.
I think we're gonna go and try to resolve it, Judge.
You got 2 weeks.
That's perfect. And we make it.
Okay. All right. And Dustin Grace.
He's not gonna be here today, Judge. He's one of the guys that bonded out of jail. He was set today with the jail people, but he bonded out. So I don't know what day they reset it into. So
It was reset back in September for today.
I think he bonded out of jail.
It doesn't matter, but that's a resetting, whether he's in jail or bond.
You see when you gone out.
Yeah, if I'm not mistaken, Judge, like don't hold me to that.
But we can ask, I mean, the bond's not going to affect us. Shouldn't. Yeah.
Just don't have a client. That's 40. So.
Okay, 25 CR 80809 is called the State of Texas versus Dustin Antoine Grace. No answer here in the courtroom. I asked the bailiff to please call into the hall for Dustin Grace. Dustin Grace.
You bonded out on the 11th.
2 days ago.
But he knows we had an announcement today. He still needs to be here, whether he's out or in. Needs to be here.
I called him about 2-3 times. Nobody's out there.
Well, maybe he's out. Maybe he's out there somewhere. I have hope. I have no hope. Now, all right, defendant has failed to appear. The warrant shall be issued for his arrest. And
Bond's 15,000.
15,000, it's doubled to $30,000 plus the defendant must have a GPS device as a condition of bond, so we know where he is when he's not here, when he's supposed to be. And Don, is that it?
That's it. I'm good.
Carolyn, Broussard. See what you can do on that first set, that first cluster.
Yes.
Yes.
Mr. Broussard. Thank you. It's two cases. The first one is a motion to revoke, and then depending what you do, well,
Is it?
Yes, sir. First one, F-21 case is a motion to revoke. It's actually the second one on the docket. And then depending what you do on that, we will take care of the second case, which is in the.
Oh, hold on. I don't have a file. I have one file, this one, the state jail felony of theft on Carolyn
And then
Grissom,
the next,
Aaron Kimball.
let me see, it might be out of order. Can I see the stack, Judge?
No, I-
Actually, it might have been out of order. I didn't.
It is on the MTRP on our side. It's written as Terry, Terri, but it is the same.
that's not,
No,
Yeah.
that's not the boss.
Yeah, no, I know it's the same one. I just, whoever did it in our office did it.
it's at the very back.
Sorry.
I don't know why I would first, because it's all, it's at the back. You can't find it.
I see the job.
So, you're right. They're getting there. I'm looking there. You got, a motion to revoke probation here from 21-38622. And then a new case of theft under 25 CR 262. It's interesting is this new case is not included
Your Honor, it was
in the
admitted
NPRP.
before the plea on the older case.
It occurred before the was placed on probation.
2 months. Come on up. Please, come on. You're Terry, you're in Broussard.
Yeah.
So here with Mr. Dusler, your attorney and the state's attorney here. There are two cases we're dealing with, as you probably know. In 21-38622, this is a motion to revoke unadjudicated probation where you were put on probation for the state jail felony of theft on January 6th of this year. Then there is another case, 25 CR 262, where you are alleged to have committed theft on or about November 23rd of last year, 2024. And because you have 2 or more prior theft convictions in county courts at law of Jefferson County, Texas, it's a state jail felony every time, even if it was a pack of gum. It's going to always be a state jail felony or higher, which means you're looking at up to 2 years. You get punished not just for the value of the property on a theft, but if you have prior theft convictions, then it's automatically a state jail felony. So that's just the way law is. And then we've got this other motion to revoke unadjudicated probation. That's pending. So what we consider.
We're going to deal with the motion to revoke.
All right. I need a pass and nothing but a pass. So help me God.
There won't be anything. It's unagreed to you, depending what you do on the motion to revoke, we'll take care of the second case.
Okay.
So there won't be anything like that, for the motion to revoke.
All right. Well, let's think this out. Then she has a right to appeal. Unless she hadn't waived it.
She waived the right to appeal.
No, on what I do here, she's going to have to.
Oh, yeah, but she'll.
But that's not been done. I mean, that's not done. But we're going through them. We're going through the proceeding, but then the normal paperwork that we include that not only has something to do with the defendant's rights, but also is a memorialization of what is on the record so that later someone doesn't go, I was confused. I didn't know what was happening. Nobody ran this by me. And then you have a signature in writing and all as well.
Once we dispose of the motion, what you decide was to.
Okay. Well, just, I trust you, but it's in the past, it's happened.
It'll be done.
Where that
It'll be done.
did not happen. You know, you just said it. Right, as I take a leap of faith here, in 21-38622, a motion to revoke unadjudicated probation has been filed in this case. You are Terry Lynn Broussard. Please raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your, does the defendant waive a formal reading of this motion to revoke unadjudicated probation in 38622? Can we proceed on summary?
Yes, sir.
And you were here with Mr. Deuceman, your attorney, and the state's attorney is here. Ms. Broussard, in summary, this motion to revoke probation states that on January 6th of this year, earlier this year, in this court, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of theft. Is that true?
Yes, sir.
Okay. Allegation 1 here. After you were placed on probation, the motion goes on to state that you failed to report to the probation office, the Jefferson County Probation Office, on or about March 6th, March 12th, April 25th, 2025, in violation of your probation order. Is anyone from probation here on this? Okay, because I'm going to ask a couple of questions that, what happened? Where's? I'm not certain, Your Honor.
I'm making a call to find out, bro.
Because, I need just to verify, I think this is going to work smoothly, but still on the record, I'd like the probation office, because
I'll get them right.
they're the experts. Okay, this states that you failed to report on those dates in violation of your probation order. Is that true or untrue, ma'am?
Can you repeat that?
That you failed to report those.
Yes.
You failed to report on March 6th, March 12th, and April 15th.
Somebody threatened to call on me and tell a bunch of lies over my niece. We had got in a real big fight and this and that. So when she threatened to do that, because she's the one taking the feet of my.
But you didn't show up to
But
it.
I didn't show up.
All right. So that allegation would be true?
Yes, sir.
All right. Next, number 2 states you failed to immediately report to the probation office your new phone number. I guess you changed phones and you have to keep that updated, and that's a requirement of condition 9 of your probation order. Did you fail to do
I
that?
failed to do that.
Oh, but you're going to fix that, right?
Oh, yes.
And finally, this states that you failed to provide verification of performing community service hours. Everybody on probation has to do community service hours. Did you fail to do that?
I failed exactly.
So are you stating that you, again, violated allegations 1, 2, and 3 of your probation order, failing to report, failing to immediately report your new phone number, failing to report in person, failing to immediately report your new phone number, and failing to provide verification of performing community service hours? Are all of those true and correct?
Yeah.
Are you pleading true and correct to those allegations voluntarily and because they are true as they are alleged in this motion?
Yes.
Do you understand and appreciate that a voluntary and knowingly made plea of true to one or more violations of probation, that would be enough to grant the motion to revoke probation? Your probation can be revoked and you can now be sentenced up to the full range of punishment. This is a state jail felony, which carries with it no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today? Yes, I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. There was restitution owed, it looks like, in the amount of $119.70. Was that ever paid back?
One time I paid my probation.
Council, I spoke to her, that she's been testified first.
I haven't paid no.
You paid some of your fees, but they didn't pay.
Generally, it goes to fees first, and then what's left over goes to restitution. But it was $119.70.
That's what I'm supposed to pay once a month, $119.
But you never paid it. It never was applied since you were placed on probation.
Well, I thought I went in there and put some money down.
I know you put some money, but that's going to be for other types of fees.
Oh,
Every
okay.
every probationer has to pay monthly fees for probation, kind of like they're paying for their probation. And what do we do about the restitution, if anything?
If you keep her on probation, you can continue to order it as you have. If you revoke her and just order the restitution as part of the sentence.
Well, the next question would be, how would you pay for it? How would you pay back the restitution? Do you have an income?
I mean, disability, I get $9.54 a month.
Yeah, but you still have to pay for your necessities of life, don't you?
Oh, yeah.
What, do you have money left over?
Yeah. After I pay my probation, that's 120. And then all that's the rest of it. I pay rent, pay cell phone.
Yes, ma'am.
And pay a way to get back to work, which I do part-time. And I have food stamps. I get $200 worth of food stamps. I'm all good. $70 worth of hygiene.
All right, let's hold that just in abeyance here for just a moment. Let me go to this new case. This is a theft, state jail felony theft. Similar in to the previous case we were talking about, since she has 2 or more prior convictions of thefts alleged in each of these 2 indictments we were working on. Anytime you commit a theft, even if it's a pack of gum, it's a felony. What was the value on this theft in 25 city CR 262? It looks like from Dillard's.
It was from Dillard's. There was a co-defendant. I think the aggregate was around $600, but everything was returned, to my understanding.
So there's no
restitution
on that one, right?
That's correct, Judge.
All right. Okay. Now let's go back on 38622. What the court's going to, this court requires people to pay their loss back. That's how you fix it.
Okay.
Okay. So what I intend to do is revoke her probation, place her on regular probation. Okay. She has 94 days credit on this. So we put her on, converted to a regular probation, essentially for the purposes of getting the restitution paid back and hoping that this deters Ms. Broussard from stealing in the future. That's what I'm going to do.
Okay.
All right. Okay. Does the state need to present anything here? Because I think a knowing and involuntary made plea of truth that she's made under oath is enough to warrant the revocation.
Nothing from the state further.
Anything to add? If not, Ms. Broussard, what I'm going to find on this motion to revoke probation in 38622 is that you have pleaded true to allegations 1 and 2 and 3 of the motion to revoke unadjudicated probation of those violations voluntarily, knowingly, intelligently. That is enough to grant this motion to revoke probation. Be granted by a preponderance of the evidence or greater. Your deferred or unadjudicated probation is hereby revoked. And you are hereby found guilty beyond a reasonable doubt of this underlying state jail felony of theft. In that original disposition on the plea hearing, you pleaded guilty to the state jail felony of theft in paragraphs 1 and 2 of the indictment voluntarily, knowingly, intelligently. That was enough to grant that, along with other documents supported your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony. You were hereby sentenced to confinement in the state jail for 2 years. That confinement will be suspended. You are placed on regular probation for 4 years. There will be terms and conditions of probation that have been normal and customary that you have failed to follow. Make sure you get it done. Most importantly, you owe restitution in this case in the amount of $119 to the standby. To the complainant, Jesse Ramirez, who I believe worked at HEB Pantry where this occurred. 3025 Dallin Road here in Beaumont, Texas. So can you pay that back? The quicker you pay that back and everything else is fine, I can then terminate this probation.
Okay. So in other words, but I
You
can.
need to pay your money back, and there, you got to serve a third of the time. But once you do that, we can get this off your back, and the probation office can move on to other clients. All right. Now we go to 25 CR 262. What are you going to do now?
We just sent to her a agreement for pleading guilty. Same thing, 2 years, probate for 4 years from.
No, I'm not going to do that on this.
Whatever.
Is there any restitution here?
There's not
No
restitution.
Signs with it.
Okay.
Okay.
Whatever feels appropriate.
What is her credit on 262? Is it 94 days on 216? Because I was going to just do time served.
Okay.
Yeah, it's 45 days, Judge. The one before she had credit before she was placed on probation. So that was-
All right. All right.
So she only has 45 days.
That would have to be a roll for. Okay.
So we'll do. Okay.
You'll just change
That's
that.
what I plan to do.
You just change that on the line.
Okay. Y'all get those done?
We've already sent the paperwork,
Oh,
Judge.
okay.
You can just change it on the plea bargaining agreement or on the will.
We did it under the terms of probation, so it just needs to be changed to 1244.
$25 CR 262 is now called the State of Texas versus Terrellin C. Broussard. That's you, present with Mr. Dusler, your attorney, and the state's attorney, Dust, the defendant. We have a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yes, sir.
In summary, ma'am, this indictment alleges in paragraph 1 that on or about November 23rd, 2024, going on a year, you committed theft at Dillard's of a value of less than $2,500, and it looks like it involved some items that when you were stopped leaving the store, they recovered.
Okay.
It's generic,
Various items of.
various items. All right, did you commit theft that day and were arrested? All right, yes. Paragraph 2 goes on to allege that you have 2 or more prior convictions of thefts in 2002 and 2018 out of County Courts of Law 3 of Jefferson County, Texas, and County Court of Law 2 of Jefferson County, respectively. Is that allegation Are those allegations true and correct that you have previously been convicted of thefts
Yes, sir.
on those times? So paragraphs 1 and 2 will constitute a state jail felony with 2 or more prior theft convictions in courts of law that are a county court at law or above in jurisdiction. Then when you just, any kind of theft is automatically a felony.
Okay. So in other words,
So you're facing no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment range you are looking at? By pleading guilty to paragraph 1 and true to paragraph 2 in this state jail case. Stand by. So you'll have to, this is going to be a little awkward, so just work with me here. The agreement's been reached where your punishment of the state jail felony will be reduced to a misdemeanor punishment under section 12.44 of the Texas Penal Code, which states that a court may punish a defendant who is convicted of a state jail felony, which you're about to get convicted here on this, by imposing confinement permissible as punishment for a Class A misdemeanor, which is up to 1 year in the county jail. After considering the gravity and circumstances of the felony committed and the history, character, and rehabilitative needs of the defendant, the court finds in this case that such punishment under section 12.44 of the Texas Penal Code would best serve the ends of justice under these particular case. Under this particular case, you have 94 days credit. So still have to, there's still going to be some, well, it's, I'm just going to give her the credit that she served. 94, that's what we're looking at.
Judge, I believe it's around 40 in this case. The 94 was for the motion to revoke case.
She said.
Yes, 45.
45.
All right. And that's what it will be. None of that's. Well, let's fix all this.
Thank you.
Misdemeanor punishment. Did you say 45 days?
5 days.
If I follow this agreement, you have no right of appeal of your case. Do you understand, ma'am?
Yes, sir.
How do you plead to this state jail felony here in 25 CR 262? Guilty or not guilty?
Yes, guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes.
Ouch. I showed you what's marked as Station Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence without objection admitted. In this indictment, you have you're pleading guilty to allegation 1, paragraph 1, which is illegally appropriating or stealing clothes of a value of less than $2,500 from Village. Is that correct?
Yes.
And then paragraph 2, alleges that you have 2 or more prior theft convictions out of the County Court at Law 3 and County Court of Law 2 of Jefferson County, Texas, theft convictions in 2002 and 2018. You have pleaded true to all of that today. And paragraphs 1 and 2 constitute a state jail felony, which means you face no less than 180 days up to 2 years in state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
And furthermore, the agreement has been reached in this case that you would be found guilty of this state jail felony in 262, but punished as though it were misdemeanor punishment pursuant to a state jail felony conviction, which is allowed under section 12.44 of the Texas Penal Code. Do you understand?
Yes, sir.
If I follow all of this, you have no right of appeal of your case. Do you understand?
Yes, sir.
So how do you plead then to this allegation 1 of theft of property from Dillard's, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty? And
Yes.
paragraph 2, which alleges those prior convictions of thefts out of County Courts at Law 3 in 2002 and County Court at Law 2, both of Jefferson County, Texas in 2018, are those thefts alleged that you committed all true and correct as they are alleged, and are you pleading truth to that voluntarily and because those allegations are true?
Yeah.
I show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney. Everything is true and correct. State's Exhibit 1 tendered into evidence and without objection. Among other things, this states you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You understand what you're charged with. You're guilty of the crime charged than any lesser included offense. And you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence reports waived.
Yes.
In 25 CR 262, if nothing further, Ms. Broussard, I'm going to find you are pleading guilty to paragraphs 1 and 2, which constitute the state jail felony of theft. You were doing this voluntarily, knowingly, intelligently. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of the state jail felony to support your guilty plea. I now find you guilty beyond a reasonable doubt of the state jail felony. However, in accordance with this agreement, you are going to be punished as though this were a misdemeanor punishment of Class A misdemeanor up to 1 year in the county jail. You were hereby sentenced to confinement in the county jail for 45 days in this case. This sentence shall run concurrently with the other sentence in 1386222. Now, even though you're punished as though it were a misdemeanor, it's still a state jail felony conviction. That's not good to have. You have to be careful and follow the rules.
Yeah.
Will you do that? Promise? Oh, okay.
I promise.
All right. This should finalize this case, and we're going to be placed on probation here on this other one and get that restitution paid back as soon as you can. Okay, ma'am? Thank you. Anything else?
I just need to give you some chronology, please. We're right thumbprint. Right thumb. Yes, ma'am. Okay, that's fine. You get a hold of the I'm getting much stronger than that. Channels.
Aaron Kindle.
Okay. All right, go back.
We got 2 cases on Mr. King.
Man, walk this way.
Now's not the time to faint, ma'am. Hang in there.
I'm satisfied. That's for me.
She sounds happy. Two cases. No. Does he need to,
Yes.
we had,
No.
it's going to, anything else you want me to add?
No, thank you.
Aaron Kimball? That's you, sir? Yes, you have to speak out for us.
Yes, sir.
Please come first in front of that lady. She'll swear you in and then we'll take care of these cases. Thank
All
you.
right.
Raise your right hand for me, please.
There you go.
Swear or affirm to have the knowledge of the net yourself you got. Swear or affirm to have the truth.
He speaks fast.
About the truth, so help you God.
You're swearing to tell the truth in this proceeding.
She'll talk fast.
No, I'm sorry.
She just speaks fast. Wow.
You have the right thumbprint? Yeah, that one. Yeah, sorry. Okay, put it right there. Do it one more time. I need the whole thumb.
Nothing but the thumb.
Put it right there.
So help me God.
Okay, perfect. Proceed, Judge.
Be said. And you were Aaron J. Kimball, correct, sir?
Yes, sir.
Present with Mr. Dusler, your attorney and the state's attorney. We have two cases here. And this is 25 CR 1025 and 25 CR 1026, two indictments. In each of these cases, does the defendant waive a formal reading of the indictments and the arraignments? Can we proceed in summary?
Yes, sir.
Bear with us here, Mr. Kimball. In summary, 25 CR 1025 alleges that on or about July 6, 2025 in Jefferson County, Texas, you committed the third-degree felony of obstruction or retaliation. And this looks like it involves threatening to harm another by assault in retaliation for the services of the victim who was a public servant, namely a Beaumont police officer. In 25 CR 1026, this goes on to also allege on or about July 6, 2025, you committed the offense of the third-degree felony of harassment of a public servant. And it looks like it's the same complainant, the same victim. In one case, it's alleged that you threatened to harm him and his family. And in the second case, it looks like your saliva went onto the complainant, spitting somehow. So each of these are third-degree felonies. Do you understand what you're charged with here?
Yes, sir.
These, the punishment range is the same on each case. You're facing no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement's been reached. In these cases, you'd be pleading guilty and sentenced to 3 years, it looks like, in prison in both cases.
Yes.
And these would run concurrently. Is that your understanding of the plan?
Sure.
If I follow these agreements in each of these in each case, and this is the plan in both cases, if I follow these agreements, you have no right of appeal of your cases. Do you understand?
You understand? Yes. And you say yes.
Okay. How do you plead in each of these cases? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are indeed guilty of these offenses.
Yes, yes, sir.
I show you in each of these cases what's going to be marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney? Are the contents true and correct? Okay, State's Exhibit 1 is tendered into evidence without
No objection.
objection. We got a problem here. Look at Aaron.
It's the tablet.
I know it is. Yeah. Here's Aaron, this is what we need to do. I'm gonna give this back to you and here, work with me. I got to do this myself. Put this thing right up over it because if you put your hand over it, it erases it when you're writing your name. You've got AR. We just need to get the other 2 letters. See, just add the other. Yeah. Because if you put your hand on it, it erases what you're doing for weird reason. We're getting new tablets. My God, but we can't get them fast enough.
Okay. Yeah. Just on. That pays all right. or-
Yeah, yeah, I think the others are good.
Okay. Oh, sorry.
Don, what you doing?
I was trying to lose it. And you'd like to.
Yeah, that's good.
This tab, this file, which is a different one. You get this, Charlotte.
And the way you normally write your name is you put Aaron, don't you?
Yes,
That's the way you write. Mhm. It's like the president. He puts Donald.
Thank you.
25 CR 1026. Let me look at this real quick. Make sure. Yeah. We're gonna do the same thing.
Okay.
And in fact, it's
I just feel I was having trouble with my own signature and
yes.
Yes.
I think, Aaron, you're gonna have to write, it looks like 3 different times, yeah,
Okay.
on that one too. See, your letters didn't come out of, your AA comes out and then RON, but right on that, on that other
Yeah, you're gonna
folder.
down a little bit.
Yeah.
More than.
God bless you. Powell.
Okay. Okay, I think that'll work.
That's not the only page.
Oh, it's on.
No,
Sorry.
go scroll to the next page. I think we've got 3 pages.
Okay. Okay, I just need an end on that one. Oh, just a second. Okay. Now it doesn't write advance, so explain it again. There it is. All right. I think we got it.
All right, so on each of these cases in 25 CR 1025, you understand fully what you're charged with, obstruction or retaliation on a public servant in 25 CR 1025, and harassment of a public servant in 25 CR 1026. These both were committed at or about the same time on or about July 6, 2025 in Jefferson County, Texas. And each of these are 3rd-degree felonies, which carry with it no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed on each case. All of that, do you understand as being accurate? All right. The agreements in each of these cases, you would be pleading guilty, sentenced to 3 years in each of these cases. These shall run concurrently with each other. Is that your understanding of the agreements?
Yes, sir.
If I follow these agreements, sir, you have no right of appeal of your cases. Do you understand?
Yes, sir.
Gotta change this to 025. What are we gonna get in the pass?
They've been ordered, Judge, but
Was it
yeah.
snail? Snail's bringing it over?
Well, we'll check the tracking.
That's good on that. Send this back to me. It was in this one. It's 25 CR 1025. Yeah, it came out, the two came out like a 7, and that's going to, since it's running concurrently, we don't get the wrong case number. You got to be put to the right case number so you get credit. Because it's 1026, not 1076.
All right.
All right. In each of these cases, 25 CR 1025 and 1026, Mr. Kimball, you have pleaded guilty voluntarily to these third-degree felonies. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea in each of these cases from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt in each of these 2 cases. I am following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years on each case, to run concurrently. Do you understand what has happened today, sir? All right, anything else to add? No, sir. That is it. Thank you very much. Thank you. Yes, sir. Take care of yourself. Yes, sir. Here it is. Will you give me this, please? Thank you. Sure. I didn't get you anything, eh?
That's okay.
Gavin McMains. Gavin McMains.
Who also need this? Right in front of me.
McMains, where is?
You have to wait.
Thank you. I'm going to leave.
Well, we try to get these things put on the network there. Why don't we try to put these discovery certifications on the tablet?
Because that would be too easy.
Why don't you get it right on that?
Well, I think the problem
That'd be way too
is
easy.
getting the attachments on the discovery attachments that the state.
He needs to come in front of you first. Sir, right over there. Thank you. She's going to swear you in on some documents. Thank you.
Right there.
Okay.
Mrs. Gavin?
Yes.
Swear or affirm to tell the truth, the whole truth. I think that's the first step you got.
No.
Okay, you tap your right hand print. Okay, place it flat, don't roll it. Okay, do it again. No. You get up again. There you go. All right. Do the same thing right there. Okay, go stand in front of the judge.
Here, sir.
We now call 25 CR 1138, the state of Texas versus Gavin McMains. That's you, sir?
Yes, sir.
Present. With Mr. Doodler, your attorney and the state's attorney, does the defendant waive a formal reading of this indictment and the arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about May 27th, 2025 in Jefferson County, Texas, you committed the second-degree felony of robbery. Do you understand what you're charged with here?
Yes, sir.
If convicted of a second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty, not found guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500. Is there a loss here?
That's what I'm looking at, Judge.
If there's a loss, you have to pay it back,
There
restitution.
was $800 worth of THC
Was there?
products taken. And
You know, you were there. Did you take something and keep it?
So like 3 things.
I know, but what were they?
THC vapes.
What's that?
THC.
Yeah, I know, but what is,
Vaping.
No, I'm talking about the value.
Oh, the
of
value.
those. I've-
He said 800.
According to the store owner clerk, they took approximately $800 worth of THC vape products and they destroyed a display which would cost about $700 to replace. That's about $1,500 in restitution.
Is that your understanding of what happened, sir?
Yes, sir.
So it looks like you're gonna have to pay $1,500 back as part of this probation. And if you fail on probation, your probation could be revoked. You could then be found guilty and sentenced up to 20 years in prison. You don't want that, right?
Yes, sir.
No. So and we're gonna put you on probation here for 10 years, but I'll shorten it to 1/3 of that if you do well.
Yes, sir.
You gotta do well.
Yes, sir.
But overwhelmingly, most of the people on probation do. So there's no reason you shouldn't be that way. All right. So you're looking at deferred or unadjudicated probation, up to 10 years, fined $500, ordered to pay restitution, $1,500.
Yes.
To the complainant in this case, which is the person's name in the indictment.
Judge, since he's juvenile and certified, we'll waive the fine of the 500 so he can pay the restitution. Concentrate on that instead of the fine.
Did you hear that?
Yes, sir.
They're already getting a break.
If it's just part of this, I'm going to talk.
If I follow this agreement, sir, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this second-degree felony of robbery, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will,
Yes,
and because you are guilty?
Yes, sir.
I'm going to show you the mark of State's Exhibit 1 here. Did you sign this document? Understand it? Discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No, sir.
Without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1 made a part of the record for all purposes. Pre-sentence report is awaited here. Thank you for your work from the probation officer. And I've got this wonderfully prepared probation order. If nothing further to add, I'm going to find in here, Mr. Gavin McMains, you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But what we're going to do is defer any finding of guilt so long as you follow these terms and conditions of probation that the probation officer is going to go over with you. Make sure you do. That's your lifeline. You won't be found guilty of a felony offense. If you do that, you don't need a felony. You know how long a felony you have to carry for the rest of your life.
Yes,
yeah, that's a long time. There will be terms and conditions of probation, which are normal and customary for this type of probation, including you will pay restitution in the amount of $1,500 to the victim. You do that, and that goes a long way to getting your probation shortened, and you get rewarded for doing well.
Yes, sir.
Please see the probation office, do well, and then do better,
Yes, sir.
and put this behind you. And,
Yes, sir.
okay. Thank you. Thanks. Thank you.
Yeah.
Ashlyn Wilson.
He's bringing
Wilson? Over here, please.
your print.
First five names for me. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, self is God. Okay. Each of you will right thumb print, please. Place it flat right there. You get up one more time. And then place it flat. Okay, you know, things don't forget.
And we now call 25 CR 986, the state of Texas versus Ashton Wilson. That's you, Mr. Wilson? Present with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment, sir, alleges that on or about May 21st of this year in Jefferson County, Texas, you committed the second-degree felony of aggravated assault causing serious bodily injury to the victim. Do you, and it says you struck him about the head and body with your hands and feet. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 8 years in prison, and this sentence shall run concurrently, I guess, with another case that you already have, 24-1327. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily on your own free will and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, Mr. Wilson, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Is a pre-sentence report waived here? Anything else to add by either party?
No, Your
There's an issue we hadn't talked about, but we need to talk about it. What are we going to do on the judgment as far as a deadly weapon?
Just since there's serious bodily injury, yes, since serious bodily
finding is going to have to be made.
That's fine because there was a deadly weapon finding on the previous case as well.
Okay, and this is going to be the deadly weapon here, or the defendant's hands and feet.
It won't change. Yes, sir.
All right. Okay, if nothing further to add, I'm going to follow this, Mr. Wilson. I'm going to find that you are pleading guilty today voluntarily to this second-degree felony of aggravated assault causing serious bodily injury in 25 CR 986. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault as indicted in 986. I'm following this agreement. You were hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 8 years. You will be given credit for all time you have served in accordance with this case. An affirmative finding will be rendered on the record in the judgment that a deadly weapon was used in the commission of this offense, namely your hands and feet. Do you understand what has happened today, sir? Anything else to add here? Okay, good luck for you. I have Earl Keeling. Reagan, how about Angela Ashland?
That's mine, Mr. Laird's.
That's yours and Mr. Laird. Huh? Do we need the defendant out? What? What about?
This looks like the extended inpatient requirements, but it says outpatient. So possibly.
Oh, because it's part of the form. So all of them makes that same thing, but it doesn't matter. You can't, there's no word included.
All right. We've got a
competency issue that she's not competent, but they're recommending outpatient, but she's violent. And they also, one of them checks recommending outpatient and there's no place to put her. The mom and them won't take her home. There's nobody to take her at home. So we're recommending that she go back, be either civilly committed to inpatient.
How are we going to do that today?
Well, we've got the 2 certificates that says she's not competent, and since she won't restore within the normal period of time, then we can proceed under the civil commitment proceeding and put her back in. Even though just because I recommend it doesn't mean you have to follow it, especially if there's no place for her.
Worried about her danger to others, but herself too.
Yeah.
Right. Yeah, that's the whole concern is, and they even, one of the doctors in his certificate, he mentioned she got aggressive with him, and she's still having hallucinations. We're just worried about her. If she gets out for outpatient, she's going to.
Her out.
If you would like to bring her out, Judge, but I don't think that we need her out.
What are you asking on her behalf?
On her behalf and on her family's behalf, I'm asking that we proceed in the way that Mr. Laird has
I'm
described.
talking about bringing her out one step at a time.
I'm requesting not to bring her.
Okay. All right. Then we call 20-35717, the state of Texas versus Angela Ashe. Ms. McNally is here representing the defendant, and the defendant is a few feet away in the holding cell, but the defense urges the court not to bring her out as the paperwork has been done. The defense attorney has spoken and dealt with the defendant, and the defense is stating that it's probably in the best interests of justice and safety for everyone that the defendant remain in custody, and she will be waiving all rights of appearance here in this hearing in face-to-face, and we will be moving through with a determination of incompetency and an order of civil commitment for her treatment.
Yes.
Okay. So In 20-35717, this is State of Texas versus Angela Ashe. The defendant, due to a violent nature of the defendant and her mental health, which needs constant treatment, the defense attorney on her behalf is urging that she not be brought forth. She is in the holding cell, and it's in the best interest of safety for all concerned that we proceed without her presence. But the defense attorney has attempted to discuss all of this with the defendant, and the necessary documentation has been prepared so that in her best interest, the defendant's best interest, that she will be deemed incompetent to stand trial, and that she meets the criteria for civil outpatient. Even though outpatient civil commitment, it is in the best interest for her and others that this civil commitment be ordered as an inpatient order of commitment pursuant to Article 46B of the Texas Code of Criminal Procedure. All that right?
Yes, Judge.
All right. In 235717, in summary, this indictment, which was handed up back in October, 5 years ago now,
Yes.
alleges that on or about April 20th, 2020, in Jefferson County, Texas, the defendant committed the third-degree felony of assault on a public servant. And this involved the defendant assaulting an emergency medical services personnel at Christus St. Elizabeth Hospital while the complainant victim was providing emergency health services to the defendant and was assaulted about her face by the defendant's hand. This is a third-degree felony. If convicted, carries with it no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. This case has a rich history of the defendant being declared incompetent to stand trial, and here we are again. And the court has before it a package of documentation dated September 23rd, 2025 from the University of Texas Health Services Health Science Center at Houston, where the defendant was evaluated. And in summary, this cover letter for Angela Ashe, the defendant in this case, in this cause number 20-35717, provides that the above patient, Angela Ashe, was admitted to the UT Health facility on April 18th, pursuant to Article 46B.073 of the Texas Code of Criminal Procedure. After this court deemed the defendant to be incompetent to stand trial, it was the opinion of the evaluators that the defendant is still currently incompetent to stand trial and is not likely to be restored to competency within the time frame statutorily available. The treating physician to the defendant further advises this court that the defendant meets criteria for outpatient civil commitment as of the date of this letter. There are 2 certificates of medical examination being submitted in this package, which this court will call Court's Exhibit 1 on this date. And along with this cover letter, there is from Chief Operating Officer Dr. Daniel Doyle of the University of Texas Health Science Center at Houston, who treated and evaluated the defendant. There's a cover letter requesting that the defendant be declared stating that the defendant is deemed incompetent to stand trial and is not likely to be restored, and that the defendant should be placed as a patient in a civil commitment setting, which this court is going to do based upon the recommendations of both parties, that this should be an inpatient civil commitment based upon the defendant's status at this time as being of having a violent nature. State's exhibit, court's exhibit 1 with this cover letter also includes a trial competency evaluation report, which is an 8-page document signed by Dr. Samantha Guzman, Gozman, who analyzed and evaluated the defendant and opined that the defendant, Miss Ashby, is presently incompetent to stand trial and that she is unlikely to be restored within the time frame allotted, as she continues to demonstrate limited frustration tolerance, tangentiality, circumstantiality, thought blocking, possible internal preoccupation, illogical thinking, and guardedness. These are impairments are precluding her ability to rationally understand the proceedings against her and assist in her defense. She appears to lack the capacity to disclose pertinent information to her attorney, engage in reasoned choice of legal strategies, and is unable to exhibit appropriate courtroom behavior and testify relevantly. The records also suggest she may lack current capacity to rationally understand the allegations against her. Thus, the treatment recommendations are by her treating physicians conclude that she would benefit from continued psychotropic medication treatment and monitoring, mental health services, and case management. And it is recommended she establishes continuity of care with the physician psychiatrist in order to identify her alternative interventions for continued thought disturbances. And she may also benefit from brain imaging and comprehensive neuropsychological testing to pinpoint areas of the brain that may have been affected by her chronic conditions and substance abuse, as well as develop interventions accordingly. And it is further recommended that the defendant participate in individual therapy and recovery services in order to gain coping skills, maintain sobriety, and remain compliant with medication. All of those suggestions this court will order and infer in its order that these recommendations from Dr. Guzman be applied to her order of continued inpatient treatment that this court is going to order. There are 2 physician certificates of medical examination for mental illness that have also been attached to these documents. One signed by Dr. Lokesh, Lokesh Shahani, which states that the defendant is diagnosed with schizoaffective disorder and needs further treatment. And it is recommended outpatient treatment by this physician. However, the parties are urging this court to order inpatient treatment based upon the particular circumstances of this defendant. And then there's another forensic psychiatry report also signed by Dr. Shahani, which states that the defendant is being treated with several medications for schizoaffective disorder, a bipolar type, is incompetent and unlikely to be restored within the time frame allotted. The treatment team is of the opinion that she has achieved benefit from inpatient hospitalization, and that she is incompetent to stand trial, and that is unlikely to be restored anytime soon. There is a second physician's certificate of medical examination of the defendant signed by Dr. Tri Lee, L.E., of the Dunn Behavioral Sciences Center in Houston. And he also deems the defendant is incompetent to stand trial and is suffering from schizoaffective disorder of bipolar type. And that the defendant has a well-documented history of psychotic symptoms that include aggression, thought disorganization, and responding to internal stimuli. She is aggressive, including physical assaulting of medical those who are medically helping her, which has led to her arrest. Although she appears to improve overall, her psychotropic medications, with psychotropic medications, she is still psychotic and at risk for harm to herself and others if not treated. As she has been observed by this physician speaking to herself, becoming angry with herself, and attempting to talk, and becomes volatile when he is interviewing her. And this physician also recommends outpatient treatment for an extended period of time. And even though the physicians are recommending outpatient treatment, the parties here are recommending inpatient otherwise. And so the court will find that the defendant does fit the diagnosis of schizoaffective disorder. She is incompetent to stand trial, is not likely to be restored to competency within the time frame set statutorily available, and the court will order inpatient civil commitment for her treatment with the goal of her one day, hopefully sooner than later, being competent to stand trial in this third-degree felony of assault, which is a crime of violence. What other findings do you want me to make? We'll, of course, have to memorialize all this in a written. Is there anything else that the parties feel like I should add, state or defense?
No.
Is there a way to appoint her mom as a power of attorney with these documents, or is that something that we do separately?
Separate.
Okay.
I think that's separate.
I think you need to do that through documents rather than me.
Okay.
So that, because you're the one representing the defendant's best interests.
Right.
Okay.
I just wanted to make sure that there wasn't.
I think that's a better way to do it.
That's fine.
Not me, but I'll certainly follow through and approve whatever you need. Your request. Okay. Anything else on this?
No.
Thank you. The appropriate documentation will be prepared and hopefully she will gain competency. Leon Davis,
He wishes to set his case for trial, Judge, and he's requesting a new attorney.
bring him out, please. Thank you. Who's on this?
I am, Your Honor.
I am, Your Honor. Who said that?
He does. Whoever's to take the folks, what you need. Well, I have to do a good chance. Tell her what I do.
One of those is gives him a. Another clear. Give you the job. Not a bad guy. It's the markets.
All right, we're now calling 25 CR 225, the state of Texas versus Leon Damon Davis. That's you?
Yes.
Mr. Davis, with your attorney, Ms. McNally, and the state's prosecutors here. You are charged in this case with evading arrest or detention, and it is a state jail felony. You have paragraph 2, which shows at least four evading arrest or detention convictions. Thus, evading arrest, anytime you commit evading arrest, it becomes a state jail felony automatically. You are looking at no less than 180 days up to 2 years in the state jail, and the fine up to $10,000 can be assessed. Do you understand?
Yeah.
This is the last one was here in this court, right? In 2022, this last conviction?
That's what I have, Judge, from August of 2022. That one looks like it was a 3rd-degree felony because it was both a vehicle.
Yeah. As you know, you are not eligible for probation here in front of a jury. You understand that?
Yes.
Okay. What was off on this?
A year state jail, Judge.
Ma'am?
A year state jail.
Okay. So that's, when can we get this tried? Because that's off the table, right? You don't want that. You've decided not to do that, right?
The enhancement, I didn't get the enhancement. I thought you had to have like 3 evadings.
You got 3 evadings.
One of them in the motor vehicle.
You got them all with the motor vehicle.
Motor vehicles. I had one, and I just had one, and I had one.
You got 2. I'm sorry, you got 2 with motor vehicles.
Yeah, and I thought you had to have like it ain't supposed to be 3
No,
evadings.
2. No, 2 gets you. Yep, that's the magic number. When you got 2 that fires in something, you kind of get stuck from here on. That's why it's a good idea not to do this, because it's automatic. It's like people who commit thefts. If they have 2 or more thefts, if they steal a pack of gun, it's a gum, which is what, 50 cents? It's a felony from here on the rest of their life. Then it's similar to evading arrest. The law's treating it the same way. And what do you want to do?
They want to go to trial. Yeah.
Nobody likes that. I know. But you're looking at up to 2 years. You understand that?
And Judge, I've discussed his options with him. I've reviewed the media with him. We're just at an impasse in terms of discussions.
You've got almost 100 days credit on.
That's not.
Oh, that's not yours.
So, but I can look at it real quick, Judge, and see what he's got.
You know how much credit you had, but we're going to figure it out for you so that it's working. It's accurate the way you think it is. It should have been January 11th, right? So
That's correct, Judge.
You've been in custody since January 11th? Yeah.
Go ahead, Jim. June.
He has 113 days credit.
How can you do that? Have you been in constant or custody since January 11th when you were arrested? Oh, okay. That's it. That's why.
At least on accusation, Judge, and then
Rearrested.
rearrested. So actually,
June.
right.
In June.
He's been in custody since June of 23rd of this year. Looks like he was in custody for 7 days before his accusation. So 113 plus 7.
Okay.
So he's got.
All right. So where are we on this again? I think he's figuring out where he stands. Everybody's here. The prosecutor's here, the defense attorney, you. What are we going to do? You got an offer of 1 year. Is that what it is?
That's correct, Judge.
That, you've
we've
talked to
tried
him about.
Yeah, and we've tried negotiations, and that's
What?
the hard offer, and I've
Okay.
spoken with him
All right.
about what.
He understands he can get credit for good time or good being good
Yes.
behavior, and where that what's this is a quarter, not a half, right? He's looking at parole in a fourth, 25%.
I think
It's not an aggravated offense.
right, but I think state jail just calculates a little bit different.
Yeah.
I don't think it's a fourth. I think.
Yeah, everybody knows what it is, but I'm not. not
But
clear
I mean,
about
I've been through all of his media with him. I have had discussions with him, and anytime that I am attempting to advise legally, we come to an impasse.
Okay, all right, it's his choice.
Continue.
You know, you're looking at 2 years, and okay, and you're not eligible for probation here, so this is your choice. Okay. That's what you want. Set it for trial.
Good.
Sir?
Good. Yes. Yeah, good.
All right. I want to get this as soon as possible. I don't want him just sitting around in jail. Let's get this done one way or the other. Okay.
Understanding yesterday that he's requesting that I be released. I don't know if I'm fine to stay on if that's what you decide, but he has expressed to me that
He's a fine lawyer. He wins cases, but you can hire anybody you want, but you're not able to hire somebody, are you? Well, you get a competent lawyer, and she's competent. That's who you get. Do you want to continue to represent him?
it's his decision, Judge.
No, it's not. No, he can go hire anybody he wants, but the taxpayers' money is controlled by me, and he gets a competent attorney, which you are. But there are other competent attorneys too. But what do you want? You've talked to him. Do you think it'd be in the best interest of justice to replace him with somebody else?
I think so, because
Then
we
it's,
do not have conversations with each
Then
other.
that's done. You don't know who you're going to get, but it'll be somebody who's competent, and they'll represent you. There aren't any deals. Let's get this to trial as soon as possible. The next person on the list, get him represent, and let's move forward. Thank you. I've got John Dixon.
Yes, Judge. He also wants his case set for trial.
Yeah, now. What's the offer on this?
Half of 10.
Look at it and see what. To end up being a cap of 20 here in a minute.
Yes.
All right, come on up. 24 CR 2417. You are John Dixon.
That's it.
And you were charged with a second-degree felony of aggravated assault with a deadly weapon. If convicted, it carries with it up to 20 years in prison, and also parole if convicted and sentenced to imprisonment. You will not be paroled until you have served 1/2 of your sentence. Do you understand? Due to the deadly weapon allegation here. What are we going to do? Yeah, Ms. McNally is your attorney.
He wishes to set his case for trial.
Okay, is he eligible for probation?
He is, Judge.
Yes, is he?
He's eligible for potentially deferred from you if we would have proceeded with the cap of 10, but he's also eligible for straight probation from jury. He doesn't have any prior criminal history.
Okay. The victim in this case, y'all talk to him, I guess, and he's wants to move forward. Sometimes that doesn't happen, and that's why I don't want this time is so valuable. I don't want. Sometimes people do things and they don't help. But y'all are ready, willing and able with 200. Okay. Then it'll be set for trial. And this one looks We can try very quickly. Let's move this fast. Okay, you're going to represent him?
Yes, Judge.
Okay, good deal. Thank you. That's all. We'll set it for trial. Devontae Huff?
Judge, can we reset him to a interview hearing docket, please? That was Ms. Staub's case. I have not had an opportunity to reach out.
Bring him out. We're going to do the MTRP hearing. Give him what he needs to know about, so we don't wait. We can make a decision here, but I don't want to start over in 2 or 3 weeks. I'd rather pick up where we are so he knows this delay stuff is just killing us. Oh, no. Back in the house in the jail. He's got 2 cases,
He
right?
is, Judge.
Are they both MTLP?
They are.
Oh, yeah. Okay. You're Mr. Huff?
Yes, ma'am.
Got you on 2 cases here, sir. 24 CR 155, 24 CR 169. Who's on this?
It was Ms. Staub. I don't think another prosecutor has been.
It's like me, Jeff.
Okay. Good for you.
I'll be messed up since she's on me.
Each of these cases are motions to revoke unadjudicated probation. You're charged with state jail felonies of criminal mischief. It looks like you were placed on probation for up to 5 years. On December 2nd, and he's already pleaded true.
Yes, we were here once before, Judge, and he was reinstated because there was a significant amount of restitution involved in the cases. And now we're back here again.
They locked me up for trespassing one. That's why I'm in jail. I went here for a motion to revoke. They locked me up for trespassing.
Y'all need to amend this motion?
I don't know, Judge. I have not looked at it.
It does need to be amended, Judge. There has not been a first.
Okay, so there's a substantive offense that's come along, allegedly.
There's subsequent allegations. I'm not sure if it's a substantive offense, but
we put him on probation.
In December of 2024.
I'm talking about this allegation true in June. What did I find then? What was my resolvement on this?
You reinstated his probation.
Okay, that's done. What happened subsequent to that?
I don't know. I don't have a new motion to revoke probation filed.
He failed to report, Your Honor. He hasn't reported since continued on probation.
Okay.
It's my understanding.
You're interrupting.
Yes, sir.
Yeah.
But I'm a lawyer too.
Is that just a smart aleck comment,
No,
or just you?
No, sir.
You're going to step over me
No, sir.
all the time, the whole time?
No, sir. Yes,
You're
sir.
going to get a chance to speak, but the lady has to put down everything as the court reporter. And when 2 people are speaking, she can't do it. That means somebody gets in trouble. All right. Okay. So the
I'm sorry about that.
motion sounds like another motion to revoke probation needs to be filed.
And it seems like I have some motions that I need to file as well, Judge.
All right, then
Seems like.
can y'all do that in 2 weeks, everybody?
Yes,
So this man knows what direction he's going to be heading in?
Yes, sir.
All right.
Please.
All right, that's what we're going to do. See you back in 2 weeks, sir.
Yeah, thank you.
Okay, here. McCarrick Kirkwood.
He's a plea.
McCarrick.
I'll hold that motion for it to get it.
McCarrick Kirkwood.
Perfect.
You need to see him, right?
I do.
I do.
Yes, absolutely.
Mr. Kirkwood, this lady needs to swear you in on some things so we can get this taken care of. Please see her. Thank you.
So please raise your right hand. You swear or affirm to tell the truth and the truth and nothing but the truth, self and God. Okay, get your right thumb front. Okay, place it flat right there. Okay, you can get up one more time. Right there. Here's your moved up.
And we now call cause number 25 CR 714, the state of Texas. Is it McCarrick? Is that okay? McCarrick Kirkwood, present with Ms. McNally, his attorney and the state's attorney. Does the defendant waive a formal reading of this indictment charging him with the third-degree felony of deadly conduct? And can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment alleges that on or about May 5th, 2025, in Jefferson County, Texas, you committed the third-degree felony of deadly conduct by discharging a firearm in the direction of a habitation. Do you understand what you were charged with here, sir?
Yes, sir.
This is a third-degree felony if convicted, which means you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range that's applicable?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. You do well, and it gets closed out early in a third of the time. Another case, 25 CR 1289 will be dismissed. What is that?
It's a misdemeanor on the
Okay.
weapon, Judge.
And then you've got this Glock 19 that was involved here. This is going to be forfeited as part of this agreement to the state. Is that your understanding of the agreement?
Yes,
And it
sir.
was a $500 fine also on this deferred or unadjudicated probation. If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead in this case? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Yes.
Yes, sir.
I'll show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 tendered into evidence without objection, it's admitted. Among other things, State's Exhibit 1 states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You voted it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. John West is on the YouTube and his tie is showing. This is, do you understand all of this to be true and correct, sir? In State's Exhibit 1. State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived?
Yes, Judge.
All right. If nothing further, I'm going to follow this agreement. McCarrick, anything you want to add? All right. If nothing further, I'm going to find you are pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to place you on deferred or unadjudicated probation. This will be up to 10 years in length. You will be fined $500. You do well, it will be shortened. There's a Glock 19 that is described in this plea agreement. That will be forfeited. I guess that was recovered from you during an arrest or search of some kind. Also, there's another case pending, 25 CR 1289. That case will be dismissed as part of this agreement. Anything else we missed? You're going to see the probation officer here in just a moment. He will go over all these terms and conditions of probation. Do well. It's in your best interest. You become a better person. And this gets shortened. You don't get a conviction. If you fail, your case could be revoked. You could be found guilty then and sentenced up to 10 years in prison. And then that comes with all kinds of problems. This alleges that you discharged a firearm at or in the direction of a habitation. The use of a firearm in the commission of an offense, if convicted, will affect your parole poorly. It has a negative effect on it. You understand? So move on with your life and do better. Okay. All right. Please see that nice man. We'll see him. Thank you. Do well. Yes, sir. We've got Kendrick Malbrook. That's not good.
I'm requesting a 4-week reset on him. His media is very extensive and I just have not been able to get through all of it with.
Okay, does he need to be out?
Yeah, Judge.
Okay, there are 3 cases on Mr. Malbrough, the 25 CR 581, 24 CR 2363, 24 CR 2364. Those cases are to be reset at the request of the defense for how long? 4 weeks?
4 weeks.
4 weeks, done. And James Rollins.
Judge, we had an issue figuring out where he is. He was in Jefferson County custody
Do you have
last.
James Rollins, manage? Who's this?
No, sir. This is Mount sir.
Don't need him. It's been reset. She's working everything out. Looks like everything's going to be done in about 2 weeks. I think that ought to wrap it up. Yes, sir. On James Rollins, do we have him
You don't.
by any chance?
We think maybe the feds might have picked him up, but that also doesn't make any sense to us because he was under a hold here to resolve this case.
Those feds leave a trail.
And we don't have a trail of anything where, I don't know where he is. We were set to resolve his cases today, but I don't know if he was released or if he was picked up by a different agency.
Just have one case.
That's correct.
Failing to comply with sex offender registration.
He was in federal custody. He wrapped up his federal issues and then he was transported here for the state violation.
He's not showing up on the roster, huh?
No, sir.
No.
He's missing it.
And Ellie has looked within the Texas Department of Correction system and he's not anywhere within.
Well, okay, let's try to figure out, we're going to review this in 2 weeks because we don't want him falling through the cracks. All right, this is James Rollins, 23 CR 213. He was transferred out of this county. We are looking to find out where. Thank you. I think that's good. Quincy Taylor. Quincy Taylor. What's this Ashton Wilson on the docket? We've already done that one, right? I didn't check it off. 24 CR 2059 is called. You were Quincy Taylor?
Yes, sir.
Mr. Taylor, and you are charged here with an indictment alleging that you committed the 2nd-degree felony of aggravated assault with a deadly weapon. A 2nd-degree felony, if convicted, carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're facing? Mm-hmm. Well, it doesn't end there because the indictment also includes 2 prior convictions. One in June of 2007 for obstruction or retaliation, a 3rd-degree felony. And this states you were convicted out of the 361st District Court of Brazos County, Texas. After that conviction was final, paragraph 3 in this indictment states you committed the felony of aggravated assault with a deadly weapon, a 2nd-degree felony. And you were finally convicted of that crime in 2017 out of the 85th District Court of Brazos County, Texas. And now, after those two are completed, this alleges you committed this offense here in March of last year, a second-degree felony. So if all of this was true, found true, those prior convictions were true as they are alleged, and then if you're convicted of this, then this is what we call habitual felony status, which means you are looking at, if convicted, no less than 25 years in prison, up to 99 years confinement in prison, or life imprisonment, and up to and a fine up to $10,000 could be assessed. It doesn't end there. The allegation here in this indictment is that you committed this aggravated assault and with a deadly weapon, and the deadly weapon is alleged to have been a mug, I guess a coffee cup kind of thing. Cool. And that in the manner of its use and intended use was capable of causing serious bodily injury or death, as you intentionally, knowingly, or recklessly, it is alleged, caused bodily injury to the complainant by striking him in the head with the mug. And the way it is alleged, if this was found true, then whatever sentence you receive, you cannot be released from prison for parole until you serve at least 50% of the time. So if you were sentenced to 30, you'd have to serve 15 before you were released. So these are all serious allegations, and you have to be careful as you work your way through this one. Do you understand what you're facing? You have to speak out so I know.
I understand.
It's not good. It's bleak. But you're presumed innocent, and that's the way the law is, unless you're found guilty. Mr. West is here representing you. What are we going to do today?
Set the trial, Your Honor. We've talked about the case, and he's adamant that he's not guilty of this. So let's set him on trial.
All right. When can y'all be ready? Again, this is another fast track. He's not going to sit and languish. I want this done.
We'll be ready next week, Your Honor. We have a video of it happening. So
all right, let's get this done. Y'all be ready? Get ready. Okay, we'll set it for trial. Thank you. Got to get that done now. Benjamin?
Yes, Judge, ready.
Figueroa?
Yes, Judge.
Oh,
He's in custody.
she's in custody.
Morning, Judge. How are you?
Very well. Family well?
Oh, yes.
Yes. Burglary, 10 years to burglary. What are you going to do?
Oh, Judge, today's, we're asking for a bond. He's on deferred. He was arrested for a DWI. There's no bond set.
Hello. It's not all you're arrested for. They got three different crimes here, Les. You know that. Looks like all on August 9th. All right, we now call Benjamin Figueroa. That's you, Mr. Figueroa? 24 CR 807. You are here with your attorney and the state's attorney, Mr. Galmore.
Okay, I'm sure that.
Okay. Changing players?
Yes, sir.
In the middle of the game, huh? Okay. It looks like illegal motion there. All right, you were placed on probation in this court apparently on October 24th of last year for burglary of a habitation, a second-degree felony. Do you understand? Does he understand?
Yes, sir.
Okay, all right. Are you a legal resident of the United States? You're a citizen of the United States? Okay, good. You were quiet, and that's okay. I just want to make sure you understand the seriousness of all of this. So you were placed on deferred or unadjudicated probation for the second-degree felony of burglary of a habitation which carries with it up to 20 years in prison. So that's serious. Now, we got a motion to revoke probation that was filed in September. And it alleges that in August of this year, apparently you are alleged to have committed the offenses of operating a motor vehicle while intoxicated on August 9th of 2025 in Jefferson County, Texas, in violation of condition 1 of your probation order, committing the offense of evading arrest or detention on or about August 9th, 2025 in Jefferson County, Texas, in violation of your deferred or unadjudicated probation order, and committing the offense of disorderly conduct. Language, there's some cursing involved, I guess, on or about August 9th, 2025 in Jefferson County in violation of your probation. And then finally, it states you failed to provide verification of performing community service hours as required. And you've been on probation, let's see, going on a year. What about his community service from probation? Has he served any? None in a year? No. Okay, I have a public safety report that has been received. For the record. The court is bound to refer to this in a setting of a bond. And this is made part of the record here for the purposes of the bond hearing. And among other information, it looks like in 2012, the defendant was convicted of a misdemeanor of interference with public duties, whatever that is. Generically, I understand what it is. I'm not sure what exactly happened there. In 2023, in August, he was placed on this. We'll say this was the arrest date. He was then placed on probation by this court on October 24th of last year for burglary of a habitation. And then it looks like he was arrested in March of last year, which was before he was placed on probation in this court for driving while intoxicated. And as he was convicted, can you pull that up in the criminal history? It doesn't say where this happened. It says the arrest date was on 3/31/24. And then it says he was convicted, sentenced to 90 days probation, 15 months probation, sentenced to 90 days in custody, probated for 15 months. I guess then what we have here is now.
That was out of County Court Law number 3, Your Honor.
When?
That was on February 26, 2025.
Okay, so he was. So that's his first one. And then now we have in August 9th, he gets a DWI, and that's why they're calling it the second one, because of that one.
Yes,
that earlier one, I guess.
Yes, sir.
And then also on August 9th of 25, he's charged with evading arrest. And August 9th, also charged with resisting, which are 2 of those are alleged in this motion to revoke probation. But also on this night, also he was alleged to have committed disorderly conduct language. I think that's a class C misdemeanor.
Case was jury gave information.
All right. So the public safety report has been reviewed. Look at the probable cause activity. Okay. But on the probable cause affidavit found the defendant who was exiting his vehicle, a Chevy Silverado with keys still in the ignition, and he's holding a case of beer and then attempts to run away with the beer as the police are hollering verbal commands and allegedly physical resisting the officers, was arrested. On speaking with Brewer, he advised that the defendant allegedly did not speak to the lady in a real orderly fashion and was very rude and abusive and vulgar. And he was arrested for DWI and attempting to evade police. It's always hard to evade police and run away when you're carrying a case of beer. That's always what I've heard. It tends to slow you down. What was the result of the specimen that was drawn from him? Do we know?
Let me check, Your Honor, to Miss. No, it's above 0.15, but let me get the exact.
You live alone, sir?
Yes.
You live alone?
Yeah.
You don't have a wife or companion?
Yeah, I do have a company.
Sir?
I do have a company.
Does that person drive?
Yes.
Do they have a driver's license?
Yes.
0.191, Your Honor.
point. A little high, over twice the legal limit. But no drugs.
No, Your Honor. I don't think it was tested.
What are you asking?
I don't think it was tested.
Judge, we're just asking the court to set a bond. We would ask the court to set the bond at a lower amount, maybe 5 or 10,000, just so that he can afford the alcohol detection device that he's currently got installed in his vehicle.
All right, anything else?
Your Honor, I would just ask that it, be somewhere around $50,000. Defendant each time has, he gets intoxicated. That's what the burglary arose out of. That's what there was another evading before that got dismissed in consideration for the burglary. There was both these DWIs. It's all arising out of him consuming alcohol and in one way or another, either being very reckless with that.
Here's what we're going to do. Is save him some money, a little bit, what my master plan is, but it's going to reduce his freedom. Sir, your bond is going to be $20,000. You must stay in home confinement. You cannot leave the home except for work, food, medical needs, and you must take the most direct route to and from those locations. You're not going to drive a car or a vehicle. The companion who is going to have you drive. I don't want you behind the wheel of a car. Do you understand? Until I order otherwise. It would be catastrophic. And if you have to drive I was going to say interlock device, but what's the point? You're ordered not to drive a car. So we don't need to get to that second step. And there will be other conditions of bond. We don't commit another crime. You come to all the court settings. Is there any other additional terms and conditions we ought to set? Because this is
that Your Honor, would ask that he abide by the SCRAM program or have that ordered, that he wear the SCRAM device. That way he, should he not adhere to the court's order of him driving, that we have some second measure there to kind of keep an eye on that and make sure he's not consuming alcohol and getting out there on the road or endangering others.
What good would that do? That's not being, he has significant penalties if I catch him. If he's on a SCRAM device, it's going to have the same ramification. It wouldn't deter any misconduct, that it would deter his future and his freedom to an extraordinary degree. I think you understand how serious this court's treating it. I guess I could load you up with all kinds of contraceptive devices here to prevent you from driving a car, but if you wanted to drive one, there's nothing I can do about it. It's just, if you're caught, shame on you. I would not be lenient. Here's what we are going to do. Everybody get ready fast. Let's get this motion done. This can't be that hard. Let's get it. When can y'all be ready? 4 weeks?
I'm sure that would be sufficient.
Good. All right. Let's do it then. And then we'll see what happens next. Okay. Thank you. John. That's it. All right. Did I miss it? I've got Earl Keeling. Whatever happened on that? I saw Todd come in and he's been out.
We haven't met on it yet, Judge. This was one of Sarah's cases. I need to get in contact with the Hardin County.
Is he around? It says the defendant is in TDC.
They brought him here today.
Oh, okay.
I'm just not sure where Todd is.
All right. Well, he's not here. We'll reset this. Okay, I'm sorry. Here is the public safety report. Last case that needs to be kept.
And what about, the file for Pod's case?
I just gave it to you,
Did
didn't I? Hope so. I gave it to somebody. They do have hearings this afternoon? Yes, good.
To let everybody know. Carl Ullman.
Hey, Mr. Eads, what's your phone number again, please? Thank you. I'll call you later.
We will go on the record in the matter 25 CM 102, State of Wisconsin versus Carl Ullman. The state appears through District Attorney Kevin Schmidt in person. Mr. Ullman appears in person with counsel Daniel Chapman. We're set here today in this matter for a final pretrial. This is the court's drop dead date in which to reach any agreement with the state. Before I begin and ask for a status and where we are with regards to the case, Mr. Ullman, you are currently behind on your court-appointed attorney's fees.
I completely 100% apologize about that. I completely forgot about it. But what I can do today is pay what I'm behind to the end of the year.
Okay.
I can make all those payments right now, just in case I don't make it out here to make the payment and everything.
All right.
At least it'll be paid in advance.
I appreciate that, and I'm going to see where we are in the case and what we're doing. We currently do have a trial scheduled for starting November 17. Mr. Chapman, an update?
Your Honor, we do have an agreement. The agreement involves Mr. Ullman getting some alcohol and drug treatment in advance of the plea. He has his assessment completed. He believes he will be starting the treatment through the University of Minnesota on December 5th. Might be sooner than that.
All right.
But I would ask that the trial be taken off because we do have an agreement.
All right. And so, Mr. Ullman, that's all correct and true?
Yes.
And you've reached an agreement with the state? With the other side, you've reached an agreement of what to plead to?
Yes.
Mr. Chapman, what is that agreement?
If he does alcohol and drug assessment and begins his treatment prior to the plea, the state has agreed to a plea to disorderly conduct with the domestic abuse surcharge for costs only.
Okay. All right. Let me just take a look. Okay. And so with that, and knowing that it's going to be a domestic disorderly conduct, you would be entering a plea to that after you do the assessment and all of that therapy, correct?
Correct.
Okay, the other matters would go away and it would be for costs only. With that, the court will remove that trial, so you don't have to worry about that, okay? Now let's get this set for possible plea. Do you know how long the therapy is going to be? Did they give you an idea?
They recommended intensive outpatient. He needs to get it scheduled with the people who did the assessment, Nystrom and Associates, don't take his insurance. So he had to find a different place that would do the actual treatment. And he believes that will be starting on December 5th. As to how long it will be, I'm not entirely sure. But if we put it for, I would say, early January, I would think he'd have enough under his belt by then, hopefully, that the state would say substantial compliance.
Okay, I could set a potential plea in sentencing for January 26th or January 29th.
Either of those work for me.
1 o'clock on the 26th?
The 26th, I will be in Polk County at 1 o'clock. I could be here by 2:30-ish.
We could do 2:30 on January 26th.
That works.
All right, so Mr. Ullman, you can come up here and get your notice and then you're free to leave, okay?
Okay.
All right, thank you.
Thank you. Have a good day.
That all? No, we
No,
have
Judge.
Sarah Tiarina. She is on the telephone.
Oh, she is.
There she is. There you go. We will go on the record in the matter 25 CM 97, State of Wisconsin versus Sarah Tiarina. The state appears through District Attorney Kevin Schmidt in person. We have Daniel Chapman, Defense Counsel, in person. Ms. Tiarina appears by video conferencing with approval of the court. We're set today in this matter for a status conference. Mr. Chapman, please update the court.
Your Honor, this is my first appearance in this matter. I have spoken with Ms. Tiarina on the telephone. I have requested and paid for discovery. I don't believe it's been turned over yet, but it might have come in late last week. I have not reviewed it, and I do not have an offer yet.
Is there an offer that could be presented?
I was just appointed on this like 2 weeks ago.
That was my mistake. I started writing an offer and it's in my notes and I didn't finish it. So if you can just, I'll send it today.
Okay. All right. And can you have a discussion with her by the next hearing?
Yes, Judge.
Can we do a December 19th? Anytime?
I am set to be in trial that day, Judge, if you wanted to try to back it up.
Or we can do
I
December
expect,
17th?
honestly, I think I set that trial just to force them to give me the drug results back. And I think once I get those results, I really don't think the trial's gonna go.
How about 10:15 on December 19th?
That's fine with me.
All right, 10:15 on December 19th. Ms. Tiarina, you can appear by Zoom again if you wish, or be here in person if your attorney says to, okay?
Okay,
Ms. Tiarina, could I get your phone again, please? I think you called me while I was driving before.
okay, it's 715-416-5620.
Got it. I'll be in touch. Thank you.
All right, thank you. We are adjourned.
And I believe that was my last one, Judge.
I have a Thomas Towell.
Oh, yes. Sorry.
Thomas Towell? We need to go on the record in the matter 25 CM 155, 25 TR 455, State of Wisconsin versus Thomas Towell. The state appears through Assistant District Attorney Jose Villa in person. We have Mr. Towell in person with Mr. Chapman, Daniel Chapman. We're set today in these matters for status conferences. Mr. Chapman, please update the court.
Judge, I was just appointed. I got a chance to speak with Mr. Toll this morning. Discovery has been requested, but haven't received it yet. I think I was appointed late last week.
All right. Is there an offer that could be presented right now?
Your Honor, an offer was emailed this morning to Attorney Chapman after I noticed that he was appointed to this case.
What is the offer?
I'll discuss it with Mr. Toll.
I know, but I want to know.
The offer would be to plead to count one, possession of a firearm while intoxicated for 1 year probation, plead to the OWI third for IDIP or guidelines, dismiss and read in the rest of the remaining counts.
Okay. Now, if he wants to engage in the IDIP, well, I have to look. He's in Siren, so he can in our program. Mr. Towel, I don't know if I have any, well, I have an old brochure, I think. Maybe it's new. But we have a new one up here. If you want to engage in that program, you have to get started right away. Mr. Chapman will talk to you about that. So I'm going to need to know at the next hearing if you're doing that. But I'd also be really excited if you guys decide that you want to do it, that you're already enrolled and starting, okay? And if you complete that program, then there is a strong, highly probable possibility you get the mandatory minimums, and any jail time could be on electronic monitor at your cost, okay? So those are positives, but talk to your attorney about all of that. Let's get the matter set. Would you like to come back for your December 19th, or is that too soon?
No, that'd be fine, Judge.
Couple months. And so since it's a couple months out there, again, if you are interested in that program and you and your attorney talk about that, I would try and get enrolled prior to that next hearing date, okay?
Okay.
All right, so December 19th at 10:15, come up and get your notice and you're free to go. Okay, that's it for you, Mr. Feliski. We have Joseph Smith on video, I believe still from Pine County.
Yes, Your Honor.
There we go. We will go on the record in the matters 22 CF 120, 23 CF 92, State of Wisconsin versus Joseph Smith, also known as Josie. We're here today in these matters for status conferences. I'm going to need to know where we are in these cases, but I also need to know what's going on and why Josie is in Pine County.
Certainly, Your Honor. As for the status of these cases, I was somewhat recently appointed here. I did receive the discovery late last week. I have not had an opportunity to review that or discuss that with my client. I don't appear to have an offer on file from the state, but these cases are quite old, so I imagine one should be coming shortly. As to why Mr. Smith is in custody in Pine County, I believe he was picked up there on a warrant. Is that correct, Mr. Smith?
No.
Oh, I apologize. I stand corrected. Mr. Smith, could you explain why you're currently in custody in Pine County?
Yeah, because I gotta get restructured tomorrow for my probation, and I'm gonna be going to treatment.
Okay,
I see.
so where is the treatment going to be, Josie?
I'll be in Minneapolis.
And is it inpatient?
Intensive outpatient is what they recommended.
Intensive outpatient. Do you know how long that's going to last?
Roughly, it can last up to 6 months.
All right. And so when you're in this intensive outpatient, and I think you've been in treatment before throughout the process of these cases, but you will have the ability to be able to be transported here if needed. Is that correct?
Yes.
Or would you have the ability to appear by video? Do you know?
Yes. I'm not sure. It's either I'm gonna either have a morning group or evening group. So either way, I should be able to appear by Zoom.
Okay. Now, whose case did I say, Mr. Schmidt? I know that offers have been presented a long time ago, but again, these are old, so I don't even recall, but I don't even know if they would still be in effect.
I'd have to parse what it says because it's Jim Renicke's offer and he writes his without saying what the counts are. And yeah, the way he wrote offers was confusing back then.
Okay. Because quite honestly, these are old cases and I'd like to get them resolved one way or another as soon as practically possible. But Josie, you're not facing additional new charges in Pine County, are you?
No.
So good. I mean, that's a positive, just probation hold and trying to get you into treatment, which knowing that could go a long way here as well. So let's get the matter set for a status conference. And honestly, I want to get one sooner rather than later because I want to see if we have the ability, what we're doing. How about we schedule it for October 23rd? And if you can do sometime in the morning. And Josie, you can appear by Zoom or even just telephone at that next hearing. It's basically going to find out if you are released and where you're going to be staying at or living at during that time, and what the offer has been, and if there's any discussion, okay?
Right.
So can you do 9:45 on October 23rd?
That'll work, Your Honor.
All right, 9:45, October 23rd. Okay, Josie, we'll see you then, okay?
Okay.
All right, thank you. Angela Kaiser? We will go on the record in the matter 25 CM 112, State of Wisconsin versus Angela Kaiser. The state appears through Assistant District Attorney Jose Villa in person. We have Ms. Kaiser in person with counsel Joel Feliski. We're set here today in this matter for a status. I believe the offer at one of the hearings was do an AODA assessment and an ordinance.
That was my understanding, Your Honor. I believe Ms. Kaiser is very interested in that offer as well. My understanding is that she is working on getting the AODA assessment set up.
I do.
It has been paid for.
It's for October 21st, so next Tuesday.
Excellent. And so, Mr. Villa, is it do the AODA assessment and complete all follow through, or just do that assessment and then she gets to follow through on her own?
It'd be to complete follow through, and then we would reduce to a citation, Your Honor.
All right. Okay. So what I'm going to do is I'm going to have you do your assessment, and then you'll figure out if there's going to be follow through. They might recommend a couple other therapy sessions. They might recommend nothing, actually, whatever they recommend. And then you're going to do those. I'm going to set it for a little bit out to give you time to complete everything if needed. And if you do all that you need to do and it's satisfactory to the state, your attorney will let you know if you need to come back or not come back at that hearing, or if you feel comfortable, you rather be here while everything is done on the record, you can do that as well. But can you do December 9th at 9:30?
That should work for my calendar, Your Honor.
All right, December 9th at 9:30. Okay, Ms. Kaiser?
Yeah.
You can come get your notice and then you'll be free to leave. That would be, and if that all goes as it's going to be, if like an ordinance, it would be $330.50 to pay, okay? So just so you're prepared for that as well.
Okay.
All right, thank you.
Thank you.
Kyle Matrius? We will go on the record in the matter 25 CM 141, State of Wisconsin versus Kyle Matrius. The state appears through Assistant District Attorney Jose Villa in person. Mr. Matrius appears in person with counsel Joel Feliski. We're set for a status conference. Mr. Feliski, please update the court.
Thank you, Your Honor. There was an offer made in this case that I believe Mr. Matrius is very interested in taking. It would involve completing the alcohol education course with Dave Hatch. The state, it seems, would then be open to amending this charge down to a citation without the domestic abuse enhancer.
All right, and Mr. Matrius, do you have Mr. Hatch's contact information?
I do not, Your Honor.
I am I'm not quite sure he might just do the program, and it's not one that's actually listed here, so it might be $150 or so to take. But still, that's sounds like a good offer. Here, when I set your next appointment, I'm going to put this up here. You can grab it. It just has his contact information and all of that. Hopefully, that's something that you can get done quickly. And we'll do December 9th, and we will set you for December 9th at 9:30 as well as the other individual. And if you do this before then, it could just be, if it is going to be an ordinance, you don't need to come back if your attorney tells you, or you can come back to court, but it will be $330.50 to be paid for an ordinance violation, if that's the agreement that you wish to reach. So December 9th at 9:30, you can come get your notice and that form, and you're free to leave.
I believe those are all of my 9:15s, Judge.
You have your notice too.
Just make sure you got your notice.
There you go. Oh, Mr. Benson, I just got a message from Mary. Are you waiting for Judge Tolan?
Actually, I just finished with him. I didn't think I was gonna get through that fast. I was sitting.
Excellent. All right. Well, I will quick call your case then. Matthew Richards. We will go on the record in the matter 25 CM 111, State of Wisconsin versus Matthew Richards. The state appears through Assistant District Attorney Jose Villa in person. We have Mr. Richards in person with counsel Adam Benson by video. We're set today in this matter for a status conference. Mr. Benson, please update the court.
Your Honor, on October 8th, I sent discovery to my client. I don't know if he's received it yet or not. On that same date, I did receive an offer from the Assistant District Attorney. I have not had a chance to speak with my client about that yet either. If we could have one more status.
Does it involve doing a course or a class?
It involves completing an AODA assessment and DV education group course with Mr. Hatch.
All right. Okay. So, Mr. Richards, I'm going to give you a sheet that has Mr. Hatch's information on it so that you know what it would entail. And the individual in front of you had an AODA with Mr. Hatch as well, but you're going to have both if that's, talk to your attorney if you want to do that offer. And so you'll have his contact information. I'm going to set you for this, does it work, December 9th at 9:45?
Works for me, Your Honor. Thank you.
All right, December 9th at 9:45. I do have to remind you though, Mr. Richards, that you have not yet started your payments for Mr. Benson?
I did make one.
Excellent.
Yep,
Thank you so much. So if you want to come and get your notice and get that form, call Mr. Hatch, get it all taken care of. That would be great.
Okay.
And we will see you then.
All right.
We are adjourned.
Yep.
Thank you. Jaden Daly. We will go on the record in the matter 25 CM 148 25 TR 542, State of Wisconsin versus Jaden Daly. The state appears through Assistant District Attorney Jose Villa in person. We have Emma Hunu, Defense Counsel in person with Mr. Daly. We're set today in this matter for status conferences. Ms. Hanu, please update the court.
Thank you, Your Honor. Before my appointment, an offer was made on the record. I reviewed that offer with Mr. Daly. That offer would be to plead to his open OWI first that I do not represent on, as well as drop the current matter, the possession of THC, to a site an ordinance. He would like to accept that offer.
All right. And Mr. Daly, you understand the offer. It is to amend the THC as a misdemeanor to an ordinance violation. You understand that?
Yes, Your Honor.
And do you understand, or it's my understanding that you wish to plead guilty then to that ordinance as well as the OWI first ticket?
Yes.
Okay, and you had enough time to go over with your attorney, your criminal rights, your constitutional rights, as well as, the facts of the case?
Yes.
Okay. And you're at Kemp Road in Siren?
Yes.
Telephone ends in 7537?
Yep.
Okay. As to the THC, formal motion to amend,
So moved.
granted. How do you wish to plead?
Guilty.
The court will accept your plea of guilt. As to the OWI first, how do you wish to plead?
Guilty.
The court will find your plea of guilt in both matters is done freely, intelligently, and voluntarily with having counsel to represent you. Are you currently employed?
Yes.
And where do you work?
Jersey Mike's.
Excellent. Well, that's not even, is it close? It's not even close to here.
It's in Eau Claire.
Okay. You don't. So are you in school?
No.
You just drive there?
No, I stay with my brother while I work.
Okay.
But I still live at home.
Like, that's a very far drive
Yeah, I
to go
know.
work at Jersey Mike's. Good sandwiches, good subs. But, okay. And so with regards to the OWI first, that would be $1,037.50 and a $10 blood draw fee. Yes. Oh, that's right. It's an OWI. Usually we have a different clerk who does the OWI, so our system, it's not easy to understand.
I know.
So just how much, Levy? I'm sorry.
$1,037.50.
All right, thank you.
$10 blood draw. 6-month revocation of your driver's license, 6 points on the license. If you want to get some points back, there's a class that you can take and you can earn up to 3 points to get those back or removed or whatever. With the THC ordinance, I'm only going to assess $200. I'm waiving the rest because you're already getting hit pretty hard with that OWI first, okay? How much are you able to put down?
None at the moment. Is there any way I can make payments?
You certainly can make payments. I'm going to need at minimum $200 a month.
Okay.
Okay? And so all the notices are going to go to that Kemp Road and not your Eau Claire unless you want to change it.
No.
Okay. So here's the deal. You have to make your first payment. I'll let you make your first payment in November.
Okay.
And so you can have some time to be able to come up with it, but you have to make sure you make that payment every month. If you want it to be taken directly out of your checks, you can go see the clerk right out there. You can see Amy and she'll make sure she does a wage assignment. Then you don't even have to worry about it. You don't need to, go, oh my gosh, I forgot to pay, because not only will I enter a civil judgment against you, but you could sit up to 6 months in jail and I'll issue a warrant if I don't get your payment. So it's very serious. So if you think it's easier for you to have it taken out of your check, stop right at the window, talk to Amy, she'll get it done.
Okay.
Okay? Again, first payment in November. I don't need DNA. I don't need anything. I think we are good to go. You got everything? Excellent. All right. So you don't need anything from our clerk up here. All you need to do is run, go see Amy, and we're good, okay?
Alrighty, thank you, Your Honor.
Lee Moritz. We will go on the record in the matter 25 CM 113, 25 CM 185, State of Wisconsin versus Lee Moritz. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Moritz in person without counsel. We're set today in these matters for an initial appearance in the 185 case and a status in the other. Mr. Moritz, did you receive a copy of that new complaint? And that's what it looks like in your hand?
Yes.
Did you read it?
I didn't read the whole thing.
But do you understand that charge and that maximum penalty?
I really don't.
Okay, well, it's easy. I'll just go over it with you and you'll totally understand. It's alleging that on or around June 13th, 2025, you knowingly, you did so understandingly that you violated an injunction, which is a restraining order, as people know it in lay terms. An injunction where you're not supposed to have any contact at all in any way, shape, or form at all with an individual in 24 CM 120. So they're alleging on June 13th, 2025, you violated that. You broke the law. You had contact. Don't say a word. You could, upon conviction, you could be fined not more than $10,000 and have incarceration of not more than 9 months in jail. So that's that maximum penalty associated with the charge and what the state would have to prove. Okay, and it's alleging that you did have contact, you knew you had contact, and you knew you weren't supposed to have contact with that domestic abuse injunction, okay? I would not say any facts about the case, because anything that you say here today can be used against you, okay? But if you have a question, an administrative question, I can answer that.
I spoke to Jose and he didn't help me at all. I had a lot.
Not supposed to. He's the state. He's on the opposite side.
Oh, I'd say, I don't know how this works.
Okay.
I have no idea how this works.
He's the attorney that prosecutes you, that he's wanting to protect the public interest and the allegations in both of these complaints because they're very similar. So he's not the guy who can help you.
Oh,
if you're looking,
I don't understand how any of this works.
Okay. So
I don't have enough money to buy an attorney right now. So
did you talk to, there was a gentleman, and I'm going to try and find somebody outside who can stop. Hey, why don't you please, one of you run out, Mr. Flisky's right outside, and then we can get Mr. Flisky so he can talk with Mr. Morris to see if he qualifies. Thank you, Ms. You talked to him already?
I talked to a woman the last time I was here.
Okay.
I don't
Apparently you
qualify.
need him.
I don't
Apparently
qualify
he doesn't
at all.
qualify. So, but thank you, Ms. Bauer. Okay, so you don't qualify.
But
Okay.
she told me I can only make like $200 a month, and
No, it's not that. It's not $200 a month. It's like you probably own property. If you own property.
Yeah, I do.
Then that's what
I own
cut you
quite
out.
a bit of property.
So what you would probably like to do is retain your own attorney or apply for a court-appointed attorney, but that's still at your cost and you'll still need to have money down. But if that's the route you wish to go, then you need to go outside and get that application when we're done here today. Fill it out today. It can't be any later today because I'm not going to wait until the next hearing to have you go, oh, I didn't do it. So you have to go fill that out today if you want a court-appointed attorney at your cost. It's $100 an hour, but that's far less than the other attorneys. You can pay $300 or $400 an hour for a private attorney. You can go that route too. That's totally up to you. But otherwise, it's a reduced rate at $100 an hour. Having these cases, you would need to pay $350 down.
I don't have any money, Your Honor.
Okay, so at this time, you're representing yourself, and that's fine, and you can do that. Not guilty plea is going to be entered on your behalf on this charge, as well as the last charge. But Mr. Villa, you're not his attorney. You don't represent him. He tried to talk to you about the case, but so with regards to this matter and your boots that you fill, what is an offer that can be presented?
Your Honor, at this time, I cannot present an offer. We have further cases that are coming down the pipeline, so I'm going to do a global.
Okay, so there's more referrals of the same-ish thing?
Yes, Your Honor.
Okay, so you can understand, Mr. Moritz, that from what Mr. Villa is saying is that there are more allegations of you doing the very same thing, and it looks like more charges, more cases are coming down the pike, okay? So
it's all Greek to me.
all I can do is, all I can say is I can strongly advise you that you need to not have any contact, not only because it's criminally hurtful, but because you have a domestic abuse injunction. Zero contact with BR. Zero contact. No texting, no talking, no swearing, no pushing, no third-party contact unless it's through an attorney.
Can I talk to you?
I may not be able to give you any answers.
This is my situation.
I don't know if you want to tell me your situation because again,
I want to. I want you to understand.
everything, I can't understand. Everything that you say can be used against this gentleman right over here, and he can use it And he can use it even if it hurts you.
But I need to talk to her because she did all my business work, all my taxes. And I need some documents from her to get.
Can't.
But I need that and she will not give me, that's why I keep.
I would stop. I would stop right now because
I just don't understand what's happening. I don't. I didn't abuse anybody. I've never abused anybody in my life.
But there is a domestic abuse injunction.
It's false allegation.
Well, it's in effect.
Because she came to the court first.
I am telling you right now, I'm not going to go look at the case. I'm not going to look at the facts. I'm not going to do those things.
Someone needs to.
There is in effect a domestic abuse injunction that says absolutely zero contact, none whatsoever. No text messages, no calls, no thinking hypothetically or not hypothetically, thinking towards her, no talking to people, not trying to do anything that has any contact with BR at all. Not at all. And if you need contact, you want to know, it says in the injunction, I can tell you right this because it says in the injunction, you can have zero third-party contact unless it's through an attorney. So that's your option.
I don't have any money, so I don't, my life's in your hands, Your Honor.
It's not in my hands. It's in your hands because I don't make the choices and I don't have the conduct you do. You're the one who understands what the law is prohibiting and you continue to do it the only way. And through that injunction, it says attorney. So what you're going to need to do is, I'm strongly advising you at least you can go hire an attorney for this one sole little thing.
I don't have any money, Your Honor. I don't. She took $25,000 from me and split.
I don't know what else to tell you.
I don't have any money, so I don't want to go to jail. I don't know what to do.
I would stop having contact with BR.
But I need some paperwork from her.
And I told you how to do it. I told you how.
I can't afford an attorney, Your Honor. I'm at your mercy.
There's no mercy here. I cannot be merciful. I have nothing that I can do right here at this time. An injunction says zero contact any way, shape, or form.
I understand.
Except through an attorney. So you know the fix.
I understand.
And you have the fix. You just have to figure out, problem solve to get to that, to be able to get what you need. I can't give you authority to do that.
I understand.
So what I'm going to do, how long do you think it's going to take you to review these new referrals?
Your Honor, less than 30 days.
December 10th at 9:45, December 10th at 9:45. We're going to have the next hearing and that's a status and most likely it's going to be further initial appearances. Again, all I can say is from the injunction, Mr. Moritz, and I'm trying to tell you your path and the thing that you can do. You need an attorney to just have that communication. And I know you say you don't have money, but here's the thing. Have you talked to an attorney to see how much money it'll cost just to have that communication?
$1,500 retainer.
Well, how many attorneys did you talk to?
Benson.
Oh, one. There's multiple other attorneys to talk to that don't charge $1,500 retainer just to send a letter to try and get business documents. There's more than one attorney in the world, okay? As you saw, we had at least 4 in here today. Not counting the state. Mr. Vila.
Your Honor, it does appear that we also need to set bond for these cases.
All right. The court is going to do $500 signature bond. Okay, $500 signature bond. Absolutely no contact with BR or residents.
I have a question.
Yes.
What does a signature bond mean?
A signature bond means you're going to sign the bond. You're going to understand the conditions. You come to court, you follow the law, you don't break any of the conditions. And then if you do great and you don't violate any of those things, then you're fine. You're just signing by your signature. You're saying, I'm agreeing to abide by this. If you violate, not only can the court convert that to cash, well, they have to pay $500 bail, but the state has the ability to charge you for what's called bail jumping. Okay, you're
So-
charged with misdemeanor, so if you
So
violate
I
any
sign
condition.
this bond, and if I don't communicate at all, I don't have to pay money? I don't understand.
Correct. You don't violate the bond,
So what, do I sign that today?
yes, you'll come up here and sign it right here today.
Okay.
I strongly encourage you to either find an attorney and retain that attorney, or to apply for that court-appointed attorney. Okay, and you'll fill out the whole application, but I need proof of your income as well as.
I don't have it because I don't have the documents.
Don't need those documents. I just need you to tell me, I make this much, and this is under perjury. So I make this much a month.
I don't make a steady income. I've been self-employed since 1997.
I understand you used to cut our grass here. I
Yes,
understand that.
I did, and I lost my job because of this whole situation of false allegations.
Mr. Moritz,
I don't understand any of this. I've never been in trouble with the law.
here's the thing. You know people who know about the law. I know that. So go talk to people who know about the law. And either apply for a court-appointed attorney. That's an option right there. And you don't even have to say, I don't need to know, I make $100 this month, I make $300.
Well, that's the thing. It all depends on the weather. If it rains, I mow. If it snows, I plow. If it doesn't rain or snow, I don't make any money.
You have an idea. You have an idea of how much you make, okay? You have an idea.
I don't make enough to pay my mortgage right now. It's been dry for 6 years.
Then it sounds like you could look at other employment opportunities as well. But here's the thing.
I'm 49 years old.
I'm not going to argue with you.
I don't want to argue,
Then
Judge.
stop.
I just want to go home.
I gave you my options. You have those options. You need to choose one of those options because it sounds like it's going to get a little bit deeper because the state has more referrals. I don't know how many, but it could be 2 or more cases, 2 more referrals.
I text a couple times.
An injunction means no contact, none.
I understand. What if she contacts me though, and I'm not allowed to contact?
Ignore it.
Can you make sure there's no contact on the bond?
That's what I said.
Oh, okay. That's my mention.
So if she contacts you, you do not even respond, I can't talk to you, because that's violating. Sounds like it's, kind of lopsided. Why can she contact you and you can't contact her?
That's what I don't understand.
It's the law.
See, I don't understand the law. I'm not a judge. I'm not a lawyer.
Locker.
But I need that paperwork.
Here's the thing. Again, the only reason why I know this, the only reason why I know this is because you brought your sister with you at the last hearing, that your sister's a law enforcement officer. You know somebody to talk to who knows the law. She knows the law. She knows the law. She's an officer of over 20 some years, maybe 30. She's an officer.
30 years.
So talk to your sister. And again, I only know that from the last hearing you were here. So you can't be trying to wishy-washy, tell me you don't understand the law, you don't know the law.
I don't.
You know an expert, a law enforcement officer. She can tell you all the things.
She doesn't, she's not a lawyer. She's a police officer.
Who knows the law? And if you say, hey, sister, I have a domestic abuse injunction against me with BR. Does that mean I can't contact her?
The thing is, it's false allegations. That's not justice.
Okay.
It's all false allegations.
Okay, again,
I just want to go home.
correct. No, you don't want to just go home. You want to continue to argue and to argue and to argue and to argue and to argue. So stop, because I'm not going to do this again. You're getting your one time right now to have your voice be heard, and that's it.
Thank you for letting me be heard.
And I understand you have these issues, but I can't tell you what to do. Only an attorney can tell you what to do and how to go about it. I've given you your options, okay?
Thank you.
So come and get your notice.
Thank you, Your Honor.
We'll see you in December.
Sorry.
It's not a waste of time, it's my job.
I'm very valuable.
It is, and I appreciate that. Are you with him? Are you with him? Did I miss you?
I was 10.
It's 10 o'clock. You do. Mr. Buskirk. All right, I know Mr. Felisky, so we'll see you in just 2 minutes. We will go on the record in the matter 25 CM 142, State of Wisconsin versus Scott Buskirk. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Buskirk in person with counsel Joel Felisky. We're set today in this matter for a status conference. Mr. Felisky, please update the court.
Thank you, Your Honor. There was an offer made in this case to resolve from the state that if Mr. Buskirk were to complete a DV education group course with Mr. Dave Hatch, the state would be willing to amend upon plea to the charge down to a citation. Mr. Buskirk had already begun that course, to my understanding, with Mr. Hatch in order to potentially secure an amendment to bond for the no contact condition. He's advised that he has one class remaining with Dave Hatch, so he is very close to completing the course and satisfying the terms of this offer. I have discussed that with him, and he does seem interested in taking the state's offer. So I believe that all that's left is to schedule for a plea and sentencing.
All right, and how quickly do you think that you can get the matter?
Next week.
Next week? I could do October 29th. Well, actually, the 27th, 28th, or 29th. If you think you can get that all done by then?
Yeah.
And it's going to be an ordinance, you said?
That's my understanding of the offer, yes.
That would be, it would, with it being an ordinance, it's a prepay of $330.50.
Okay.
And so if you have that paid prior to and you give all the information to your attorney, you don't need to come back to that other hearing. We can just take care of it without you.
Okay.
But if you want to be here, you certainly can as well. I could do October 29th at 2.
Sure. That'll work.
Okay, October 29th at 2. All right, so we will see you then.
Thank you.
Thank you. Yes. All right, 7919013, is this Mr. Ainley?
Yes, ma'am.
All right, we'll be with you in 1 second.
Okay.
We will go on the record in the matter 25 CF89, State of Wisconsin versus Timothy Ainley. The state appears through Assistant District Attorney Jose Vila in person. Mr. Ainley appears by telephone conference. His counsel, Zachary Fisher, appears by video. We're set today in this matter for a status. Mr. Fisher, please, an arraignment, sorry. Can you please let me know if you went over the criminal information with Mr. Ainley?
Yes, Your Honor, I have reviewed the maximum, I have reviewed the charges and the maximum penalties. We would waive any formal reading or any further reading, enter not guilty pleas, and I would ask to set this for a status on December 15th at 2:30.
Did you receive an offer?
Yes, Your Honor, I have.
And what was that offer?
Your Honor, the offer is to plead to battery for a withheld sentence for 1 year of probation. I do just want to review discovery. Given that this was a felony, I have not received it since we recently had the preliminary hearing. So I just want to review discovery before we set this for a plea hearing.
All right, that sounds good. I cannot schedule it on that December 15th date because it needs to be on Mr. Vila's date. But I could do December 8th in the morning or December 10th in the morning.
I could do the 8th anytime except 11.
How about 9:45?
That works for me if that works for Mr. Ainley.
And he can appear by, okay, good. All right, so we will see you then 9:45 on December 8th. All right, thank you.
Thank you, Your Honor. Have a nice day.
We're adjourned. in person. We have Mr. Sprick appearing in person without counsel. We're set for initial appearance in one and statuses in the other. Mr. Sprick, there's allegations of a new.
Yes, I was gonna tell you about that. It's not because I was.
Don't tell me anything about the case, the facts, because it can be used against you. You gotta stop driving.
But how do I, it's just me. I mean, how do I take care of myself if I can't get around? But I'm gonna go tomorrow and get a work permit because
That's a first step.
they told me that I could get a work permit, and so that's what I'm gonna go do.
An occupational license, you can do that.
Yep.
Second thing is get your real driver's license.
Yeah, I know. Getting that ticket kind of bummed me out pretty bad.
So now we have allegations of a new one, so you understand that charge and that maximum penalty?
Yes.
Not guilty plea will be entered on your behalf. Mr. Villa, with the new one, is the offer still stand?
Following up on that now, Your Honor.
You were supposed to get your license, I believe, in the beginning of October.
Yeah, and I've just been so consumed in everything going on with my new house and trying to get everything straightened out.
I know, but I'm gonna tell you, I understand that.
I just spaced it out.
However, if, these are crimes and you could sit in jail.
I know.
Priorities.
Your Honor, the offer is to possibly get his license and dismiss.
So it's still there. Get
Okay.
your license and it'll be dismissed. But first things first, get your occupational.
Yeah.
Now, let's put that on over here. What do you have to do to get your full license now?
As far as I know, it was just to take the test, take the permit test again, and then I don't think I have to take the behind the wheel part.
Okay.
Because I think it says 8 years, then you have to, and it hasn't been 8 years.
All right. I'm going to give you one more time.
Okay, thank you.
And I'm going to give you December 10th at 9:30. December 10th at 9:30. I am going to verbally warn you and reprimand you right now. Do not get another one before December 10th.
No, I won't. But I off the record, but per se, like, isn't it like harassment when they see you, if they see you driving and that's what they stopped you for, is because they recognize you, not because you're doing anything wrong.
Hey, you want to know you are doing something wrong?
Well, yeah, I know.
And
But I
here's the
mean,
thing, they know your face,
Yeah.
or they know your car. They know that Mr. Sprick isn't licensed.
Right.
That's not harassment. They're doing their job.
all right. Okay.
It's against the law.
I was just asking. I know it's against the law, but I was
It's
just
against the law. That's what they're pulling you over for. Get your license.
Yes, I am. Tomorrow I'm going to get my occupational.
Excellent.
Okay, thank you.
All right. Thank you. See you later. Where is Mr. Howard, where's Mr. Howard?
LT, net with Zaretz. She had paid everything but a short $28 shortfall. And apparently you paid that since I saw you last time, and the matter has been dismissed by the plaintiff. So you're apparently squared away with your rent and you're good to go.
All right. Thank you so much, Your Honor.
Thank you. Okay, good luck to you. Hope you don't have to come see me for a while.
Me too. You have a great day.
All right, bye.
Bye-bye.
All right, that was our first case, which was set on there. I thought it would be dismissed, and it was Riverside Townhouses versus Zaretz. So I made a brief record on that. If the plaintiff shows up, we'll tell her we released her. Judge Patterson's emailing me. All right, we have 3 Memory Mobile Home Park cases to start our afternoon. Good afternoon.
Good afternoon.
We've got everybody we need but a defendant.
Yeah, I don't see the defendant. This is supposed to be Alyssa Blizzard.
Yeah, we've got 3
Correct.
memory lane cases. Let's see who shows up.
Okay. Chris, how are you today? I'm wonderful. How are you? Good. Good.
One question, this rents are $560. Is this lot only?
Yes.
Yeah,
I think 2 of the 3 are.
Well, they're all listed as $560.
Right. Katie Bidwell is just lot rent. She owns her own home. And the other 2 are lot rent plus rental, plus the house payment.
So we'll have to break that down.
We can do that.
Well, we need a defendant.
That would help. I know they were all served.
Yeah, they were all personally served. We have an excellent process server here in our county. And he does a wonderful job. We recently had some circumstances with some out-of-county services that did fraudulent service. They swore they had served parties when they had not, and it caused some difficulty, as you can imagine.
Yes.
Good afternoon, Judge.
Good afternoon. We've got everybody we need but a defendant, so we're all in a holding pattern.
And just a heads up, I think I'm the only person in the office right now, so I'm going to keep my door open for our bell.
All right.
So if I start,
here's our first client. All right. So if anybody comes trick or treating or anything, you're responsible.
Oh, there's Ms. Blizzard.
Yes.
I'll send him to Rick's office for a scare.
That would do it. Good afternoon, Miss Blizzard. Can you hear me?
Yes, I can. Can you hear me?
Yes, this is Judge Middleton. I can't see you, but I see your profile picture. Are you Elisa Blizzard? Alyssa?
Yes, I am Alyssa.
All right, this is your park, Memory Lane Mobile Home Park versus Alyssa Blizzard. The file number is 251918. Your manager, Chris Corpening, is here. Attorney Stuart Wiener is here, and Meg Bauer is here from Legal Aid. You're a tenant in a landlord-tenant proceeding. We may need to break this down a little bit. They're alleging that you're behind on your lot rent and the payment toward the purchase of your trailer.
Yeah.
You have the right to hire an attorney. If you cannot afford to pay for one, the county would give you information about legal aid, or you could seek other legal assistance. As I indicated, there's a representative from Legal Aid here with us on the live feed. You have a right to have the case heard here in St. Joseph County where the property is located. And that's never been an issue. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at its first court appearance and be prepared to pay the $50 jury demand fee or file the demand in writing within 5 days. And the judge can waive the fee if you're unable to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, Community Action Agency, Neighborhoods, Inc., or if you're a veteran, you may be able to get assistance from those agencies. We sent that information to you with the original packet. You do not need a judgment against you to receive the assistance from the places listed above. Copy of the summons and complaint are sufficient. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested, the court can help set that up. And you may be able to reach an agreement with the landlord that means the case would get dismissed by a conditional order of dismissal. So we got our next people here, and we'll do their rights. Ms. Blizzard, could you turn your camera on?
Yes, 1 second. I'm trying to the phone. Okay.
All right. This was filed as a demand for non-payment of rent. The complaint says rent's $560, but that doesn't tell the whole story because there's a payment. So, Mr. Wiener or Ms. Corpening, could you break down the current arrears for me?
I can do that for Ms. Blizzard. So she has to pay a lot rent, a home payment because she's purchasing her home, and there's a $50 late fee.
All right, how much is the home fee?
The home fee is $165 a month. And the lot fee had been $530, but then it went up in May to $560.
All right, right, what's and the pleadings only show the 560. They don't show the payment. So what's the current arrearage?
The current arrearage was, when we filed the complaint, was $2,295. However, she then did not pay September and October. So there's $775 for September, $775 for October. That then gave us a total of $3,845. And then there are court costs. I get the statutory attorney fees of $75. There were service fees on process of $51.20. And then there was a filing fee of $130. The total number and amount of costs is $256.20. So if I add the rent and the costs, the total amount of the judgment I am seeking is $4,101.20.
All right, Miss Blizzard, they're indicating that through October, you owe that much in rent and lot payments and I guess a couple of late fees. What's your response to that?
So I went to Neighborhoods Inc. and they've agreed to help get me caught back up. On Friday they said that she just had to somehow get the paperwork to the landlord, and she said that that was on Thursday. She said she would be in Sturgis at some point to drop those papers off to her. But I didn't hear anything back.
It may take a while to accomplish this. But I think we can adjourn 1 week. The law requires a 1 week adjournment. It sounds like you're well in the process. Next Monday would be the 20th. Let's look at that date. I had it up and then I look for something else.
Twentieth works for me, Your Honor.
Let's see what we got. We got a busy afternoon is what we got. 150, 120, 210, 215, 220 on October 20th.
Okay. Chris, does that work for you?
Yes, it does.
Miss Blizzard, nothing terrible is going to happen on the 20th. In fact, you'd get 10 additional days from that day to pay the rent or you'd be subject to being evicted. We could even continue it if the rent was in the works. Now, let me tell you something that you need to know. The only thing that will cure this is paying the entire amount. So let's say Neighborhood Inc. gives you $3,000. You would still need to pay the balance to bring it to $4,101 to prevent the writ of eviction. The landlord can always agree to work with you, but sometimes they pay much of it, but not all of it. Now, you can share this information with Neighborhoods Inc. The amount is $4,101.20. It's gone up since the summons was served because 2 additional months have passed. Are you employed?
I just recently switched jobs, and I do have some, like a partial amount of what I owe right now. I wasn't sure how that whole thing worked, if you're supposed, because I've heard you're not supposed to pay rent.
As much as they give you, you're responsible for the balance. Of course, then on November 1st, November's rent is due. But this is more than just a lot rental. You're actually buying the trailer.
Yeah.
So I'm not sure whether they'll pay the cost of you to purchase the trailer. They may pay the lot rent, but not the purchase rent. For example, if I was buying a house and I was behind on my house payment, Neighborhood Inc. wouldn't give me my house payment. They'll pay rent, but they won't pay a house payment. So I'm not sure how much of this, how it all breaks out, but hopefully they'll give you enough money that you can maintain your tenancy. So we'll revisit this next Monday, the 20th of October at 2:20. Does that work for you?
Yeah, it's fine.
All right, you did a good job of logging in. I'll see you at that time. You should get a new notice. Share this information with Neighborhoods Inc. Okay? All right, you're good to go. Now we've got 3 more customers here that I think we can advise of their rights all at the same time. Oh, remove. She's gone. Now we have Caleb Applegate. Can you hear me? And Haley Gardner. Can you both hear me?
I can.
Yes, Your Honor.
And I have iPhone. Is that Ms. Bidwell?
Yes.
All right, let me give you a name. The clerk sets these 5 minutes apart, and they really take longer than 5 minutes, but often things are settled or dismissed in the middle, so we get caught up at some point. Anyway, you're both tenants in a landlord-tenant proceeding where your landlord is asking you to pay the rent or move. You have a right to hire an attorney. If you cannot afford one, you may request assistance from legal aid. Meg Bauer from Legal Aid is here with us on the feed and is available for consultation if needed, or you could seek other legal services. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance and make the demand in writing within 5 days of today's date, using the jury demand form, and pay the $50 fee unless the judge waives the fee for inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Department of Health and Human Services, Community Action Agency, Neighborhoods Inc., or if you're a veteran, you may be eligible for some veterans assistance. As you heard, our last tenant had gotten some assistance from Neighborhoods Inc. You do not need a judgment against you to get help from the places listed above. Copy of the summons and complaint from your case are sufficient, despite what somebody at DHS may tell you. You may be able to reach an agreement with the landlord by going through mediation, also known as local community dispute resolution. If both parties are interested, the court can help set that up. You may be able to reach an agreement with the landlord that means the case would get dismissed, which was a result of the filing of what's called a conditional order of dismissal, and we would assist, probably the attorney would file that document. I guess these are both set for 125. So let's take up Haley Gardner and Caleb Applegate. I think this is the same situation we had last time. Some of it is lot rent and some of it is payment toward the purchase of the trailer. Mr. Weiner, what's the status here?
So as of the time that we filed the complaint, which was in August of 2025, Caleb owed $3,075. That consisted of a lot rent of $560, a home purchase of $415, and a late fee. Because June, July, and August was also not paid, that increased the amount by $1,025 for September and $1,025 for October. or a total amount of rent and fees of $5,125. In addition, costs consisting of attorney fees, statutory $75, a service fee of $51.20, and a filing fee for the complaint of $130, added $256.20. So Caleb now owns $5,381.20.
Is there a separate service cost on Haley Gardner?
Haley Gardner is not before me today. Haley is with Caleb. No, this is for both of them.
All right. And again, give me the lot rent and the trailer payment again.
The lot is $560 a month. The home is $415 a month. The late fee is $50.
All right. Mr. Applegate and Ms. Gardner, do you agree with those figures?
Yes.
Have you asked for any emergency help?
I did. I don't remember which one.
Well, what does that mean?
The one that you I texted them, but I didn't get anywhere.
All right. Well, do you guys have a plan to try to catch up on this, or do you plan to move?
We would like to work something out in terms of making payments, but there's also other situations with the living that we would like to get figured out.
And what's that?
There's several situations with the trailer. One, there's a large black mold section that we're told would be fixed and has not been fixed. On top of that, we have not been given a mailbox key to our mailbox in the time that we've lived here. Whether we've been to the post office or the office themselves, we have not been able to access our mailbox.
That's been an issue at some other parks as well. All right. Well, so there may be an abatement issue, but you haven't paid rent in months and months. And you sort of did a half-hearted attempt to get some emergency help. You're buying the house, you'd lose whatever equity you had in it. You'd lose your ability to stay there and you'd be compelled to move out. So, and in order to actually, there's a way to not pay your rent, paying into escrow. Nobody ever does it right. But you could pay the rent to me if we're going to get into an abatement issue. But the law requires that we adjourn this matter at least 7 days. Are you going to ask for any additional help?
Yes, yeah, I've been seeking help through family and other situations through MDA.
Are you guys employed?
Yes. Well, I am. I was in the Navy previously, but due to the situations in the government at the moment, I am home working at Myers right now.
Where are you working now?
Myers, yeah.
Okay. Well, if you were in the Navy, you'd not be getting paid right now.
Yes.
So there's a terrible state of affairs. All right, well, I'm going to adjourn this matter to 2:30. On next Monday, which will be 10/20/25. In the meantime, I would suggest that you touch base with Ms. Corpening and you also look into these additional funding agencies, Neighborhood Inc., Community Action Agency. Haley didn't even know which agency she asked for help on. You need to be a little more focused than that because they may have some money to help you get caught up on your rent. If that happens, we could always continue the case. But continuing where we are right now, if they get what they ask for, when I meet with you on October 20th, I will tell you have 10 days to move or you're subject to being evicted. And you would be evicted on the 30th of October and the sheriff would come put all your stuff out in the street. That's not a good position to be in. So you need to go to these funding agencies, stay in contact with your landlord. This mold issue, we're gonna deal with it. For one thing, you're buying it. At some point, once you bought it, I guess it would be your problem. Now you're purchasing it. That's an issue that may need to be addressed. And legal aid is here if you wish to consult with them regarding that. Would you like to talk to the attorney from legal aid?
That would be great, Your Honor.
All right. Anyway, talk to the funding agencies and stay in contact with your landlord.
Yes, Your Honor.
How do we go about getting our mailbox key?
Yes, another issue. That's been an issue. I had a park the other day and they've been there for a year and they couldn't get a mailbox key.
Your Honor.
Chris, could you look into that?
Yes, they have to go pick it up at the post office. I don't have anything to do with them, with the mailbox keys themselves. They just pick it up at the post office.
We have been,
Yes, in Sturgis.
All right.
I'll be happy to email them and find out if they've done anything, because all I do is once they sign the paperwork here, I email the post office and they come out and change the box and then they have to go to the post office and pick it up. I'll be happy to email them back and find out if that's been done.
All right, thank you.
You're welcome.
Click on the button that says join.
Thank you, Judge.
Thank you. All right, Ms. Bidwell, can you hear me?
yes,
All right, we went through your rights. Your case is similar, but you own the trailer, all right? So this is lot only. Back up here a little bit. Mr. Wiener's office has provided a court breakdown, and I greatly appreciate those. Rent is $560 with a $50 late fee. At the time of filing, it was May, June, July, and August. Ms. Bidwell, I can't talk to you while your vehicle is moving, particularly if you're driving. I'm not gonna do this court hearing while you're driving a car. It's a recipe for disaster. So I'm gonna turn this off. I want you to pull over. You started driving while we were dealing with this.
I apologize. I'm on my way to a job interview, but I can pull over really quick.
Well, yes, you need to do that. I don't want to have an accident. I'm gonna put you in the waiting room. People treat court as an inconvenient nuisance, which it certainly is, but appearing by Zoom is a gift. And some people, one of these days, someone's gonna have a crash while I'm talking to them. Mr. Wiener, I do appreciate these court breakdowns. John Bush always did those for memory lanes, and they're very helpful to me.
You're welcome, Your Honor. I think it helps everyone to
It
understand.
speeds the process up. All right, now I've got people in the waiting room. I want to bring them all in.
Up, she's back.
Hey, sorry about that.
All right, I don't want to have an accident. All right, in this case, we're going through this, May, June, and July, and August. Has anything been paid in September or October?
No, well, I don't believe so.
All right, so it would be 610 times 3.
Right, well, there's another 2, so she paid.
Oh, times 2, yeah.
Yeah, so
610.
she had not paid May, June, July, August. That was $2,240. Then September and October, that's another $1,220. with the late fees of $300, that number became $3,660. In addition to that, she owes attorney fees of $75, service
minute.
process.
2240, 610, 560 plus 50 is 610. So
Yes,
I
I'm
added,
sorry, 610, yes.
all right, that becomes 1220. If we
Correct.
add 2240 plus 1220, we get 3460. I think you said 3640.
Yeah, that may have been a math error on my part. Well, you know
All
what? No, it was 2440 plus
2240.
2240. Oh, you know what? Chris, on the complaint, I said 2440. So there was another $200. Do you know?
That is the court.
Oh, those were
That's the late
probably
fees.
late fees.
Yes.
Those were late
Mhm.
fees.
All right, plus 200 in late.
That's why.
All right,
So then the total is
36.
3,660. And then we
All
have
right.
attorney fees of 75, service of process fees of $51.20, and filing fees of $130, for a total of costs of $256.20. And then if you add up the total rent, the total costs, I get $3,916.20.
All right, Miss Bidwell, what's your position?
I moved out and I tried to come to agreements with her. I've tried to sell my trailer, and at first she didn't approve. And I do have somebody that's going to buy my trailer for the back rent that I owe, but she won't approve them. I don't know how I was supposed to pay where I live now, like where I've been living, and be able to pay the back rent of the trailer. And
when did you move out?
I believe it was May or June.
May or June?
Yes.
All right, when you move out, you're supposed to turn in your keys and give your forwarding address in writing within 4 days of your moving. Did you give notice in writing to your landlord that you had moved?
No, I told her that I moved though.
Did you give her your forwarding address?
No.
Did you give her your keys?
No.
So is all your stuff out of the trailer?
Yes, it is. There's some garbage there. It needs cleaned out from my sister staying there. But yeah, all my stuff is out. I've tried to give Chris the trailer. She told me that she wasn't gonna give me anything for it and whatever. She was rude about it at first, and I've been trying to come to agreement since then with her, and it's really hard.
All right,
It's
well,
really hard with her.
how long was your sister in there after you moved out?
About a month.
All right.
And she absolutely
this
destroyed it.
Sister destroyed it? Oh, great. Well, this would give them the permission to remove your trailer. This is lot only, which theoretically, I'm not even sure you can do it this way, but I've been allowing it. Some judges don't allow the mobile home parks to do this, but I do it because it lets the tenant redeem it. So you moved out, you didn't give her your forwarding address, you didn't give her the keys, your sister moved in, trashed the place. Now they've got this trash trailer on their lot that probably doesn't have much value. What year is it, do you know?
I think it was a 97.
All right, Mr. Weiner, you got any ideas here?
No, a lot of these facts are new to me. Chris, anything that
Your Honor, I am working with a lady who wants to purchase her home. And I have explained to her that the past due rent has to be paid before the purchase can happen. It's not that I have not approved her, but I want to know what's going to happen with the past rent. Katie did not tell me she was moving. And I did tell her that we would possibly be interested in it for the back rent about 2 months ago, but I needed to see the inside of the house, but she tells me she can't be here. I really am trying.
All right, we're gonna continue this to 2:35. Next Monday, October 20th. There's several issues.
Okay.
Yes, go ahead.
I start a new job on Monday and I don't get out until 3:30.
All right, well, if you don't come, you'll be subject to default. I would suggest that you do get a hold of Ms. Corpening and discuss these issues. Perhaps something could be done. But we do court at certain times of the day. I hope you do good on your job interview today. But that's when it is, next Monday at 2:35. So you might need to take a break for a minute from work to zoom in. But and contact your landlord. Maybe they can work out the transfer of this property and we can close this out. But you didn't exactly follow the law when you just sort of left and let your sister trash the place. All right. I'll see you hopefully next Monday at 2:35. All right, thank you.
Thank you.
Thank you, Your Honor. Thank you,
I
Stuart.
think we're done, Your Honor.
All right, thank you.
We'll see you next
All
week.
right. Now we've got some other matters. We've got one more landlord tenant matter before we address our civil 145 matters. And that is Hagelgans. Let me find that. What do I do with it? Here it is. All right, this one is entitled Doug Hagelgans versus Kaylee Henderson. This is a property on Middle Colon Road. Kaylee Henderson is not here as far as I can tell. Mr. Hagelgans is here in the court conference room. This is filed as a termination of tenancy. Mr. Hagelgans wants her to move. Mr. Hagelgans, is she still there?
No.
She's left?
Yeah, about 2.5 weeks ago.
42191 counts 1 through 6, guilty to those first 6 counts, and if in return the state would dismiss counts 7 through 12. In regarding case number 25 CR 42802, the defendant is going to change her plea to guilty to counts 1, 3, 5, 7, 9, and 11. Those being aggravated trafficking on count 1, trafficking on count 2, trafficking on count 5. Both of those are in fentanyl-related compound. Count 7 is aggravated trafficking, as well as count 9 is trafficking in fentanyl-related compound. And count 11 is aggravated possession of drugs. In exchange for the plea, the state has agreed to dismiss counts 2, 4, 6, 8, 10, and 12. There is no agreement as to sentencing. My understanding would be a PSI would be ordered, and we'll come back for sentencing at a later date.
Mr. Bogan, is that accurate?
Yes, Judge.
The stats, if they're telling me you're going to enter pleas of guilty to certain counts from each of the indictments before we get to your change of plea, I am required to go over some things with you, okay?
Yes, sir.
How old are you?
I'm 44.
How far did you go in school?
2 years of college.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Bogan?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take any medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me two sets of documents, one for each of the indictments. The first one, the 24, case number 42191. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of aggravated possession of drugs as a felony of the third degree. That carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. That also carries with it a mandatory fine of $5,000. There is a presumption that you will serve a prison sentence on that count. The second charge is one of possession of a fentanyl-related compound, a felony of the fourth degree. That carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. Third count is aggravated possession of drugs, a felony of the fifth degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The fourth count is one of possession of cocaine, a felony of the fifth degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The fifth count is aggravated possession of drugs, a felony of the fifth degree. That carries a maximum penalty of 12 months in prison and a $2,500 fine. And the final count is aggravated possession of drugs, also a felony of the fifth degree, and that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. Do you understand the maximum penalties with regard to this indictment?
Yes, sir.
Under case number 25CR42802, again, I have a document called a change of plea. And on the second page of this document, on the line marked defendant, there's a signature. Did you sign this document?
Yes, Your Honor.
And you read this and went over it with Mr. Bogan?
I did.
And you believe you understand what this document says?
I do.
This document says you're entering a plea of guilty to one count of aggravated trafficking in drugs, a felony of the third degree. That carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. $5,000 of that fine is considered to be mandatory. That there's also a presumption that you serve a prison sentence. The second count is trafficking in a fentanyl-related compound. That too is a felony of the third degree and carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. That also $5,000 of that fine is also considered to be mandatory. There's also a presumption for prison on that charge. The third count is trafficking in a fentanyl-related compound, a felony of the fourth degree. That carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. The fourth count is another aggravated trafficking in drugs, a felony of the third degree. That carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. $5,000 of that fine is considered mandatory, and there is a presumption for prison on that charge. The fifth charge is trafficking in a fentanyl-related compound as a felony of the fourth degree. That carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. The final count is one of aggravated possession of drugs, a felony of the fifth degree, and that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. Do you understand the maximum penalties with regard to this indictment?
Yes, Your Honor.
Now, all of these charges, as I've indicated on both indictments, there are certain charges that there's a presumption for prison, but prison is not mandatory on any of these charges. Now, you're subject on both cases to a discretionary period of post-release control, which means if you are sent to prison, upon your release, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, you can be returned to prison by the adult parole authority for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, Your Honor.
But as I've said, it's not mandatory that you're sent to prison at all, even though there is a presumption on certain charges. The court does have discretion to place you into community control, what some refer to as probation. While on community control, you will have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, Your Honor.
You're presumed innocent of all these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, Your Honor.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that? To see and hear all the evidence that the state has against you, with the help of Mr. Bogan, the right to confront and cross-examine each of the prosecutor's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court will force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor at your trial. You're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from each of the indictments. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter plea of guilty, you will be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you wish to proceed.
Yes, sir.
All right, Mr. Harris.
Your Honor, if this matter is proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment. This is regarding case number 24 CR 42191. This is in regard to counts 1 through 6 that on or about November 4th of 2024, defendant Carmen Statzer was found in possession of several controlled substances. This was after a traffic stop in the city of Franklin, Warren County, Ohio. As to count 1, she possessed 14.25 grams methamphetamine, 1.2 grams fentanyl. As to count 2, 9.11 grams psilocin. Regarding count 3, regarding count 4 would be 3.48 grams cocaine. Count 5 was 0.17 grams amphetamine, and count 6 was 0.62 grams methylene dioxymethamphetamine. That is regarding the first case in 2024. In regard to the 25 case CR 42802, this was on or about December 18th of 2025 through January 3rd of 2025 in the city of Franklin, Warren County, Ohio. Carmen Statzer engaged in drug trafficking of fentanyl and methamphetamine. As to count 1 was 3.45 grams methamphetamine. Count 3, 1.52 grams fentanyl. Count 5 was 1.88 grams of fentanyl. Count 7, 4.5 grams methamphetamine. Count 9 is 2.16 grams fentanyl. And count 11 was 1.30 grams methamphetamine.
Mr. Bogan, anything on those facts?
Nothing on facts, Judge.
Ms. Statzer, did you hear the statement that he read?
Yes, Your Honor.
Do you admit and acknowledge what he said is true?
Yes, Your Honor.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we went over?
Yes, Your Honor.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court accepts your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I will order a pre-sentence investigation. We'll come back in a few weeks and do sentencing at that time. Anything else?
Nothing else,
No,
Judge.
thank you.
Thank you. Thank you, Judge.
Judge, I said.